Yes, Mr. Sir.
May please, my lord, I beg to mention item number 33, my lord.
33,
My lord, the matter has been complied with, my lord.
complied with.
My lord.
Mr. R. Sharma, learned counsel for the petitioner, submits that during the pendency of the present petition, the respondents have complied with the directions passed by the order, violation of which is alleged in the petition writ. Accordingly, he prays that he doesn't move to a contempt petition. Prayer is not objected to by the learned counsel for the respondents.
Yes, Alia, my lord, earlier.
By Mr. A. Cholia, learned counsel appearing for the respondent. Learned counsel appearing for the respondents. Also, in view of the above submission of the learned for the petition, the present contempt case.
Yeah, please, your lordship. I beg to mention item number 18.
Adhikari,
Yes, my lord.
a prayer is made on behalf of Mr. MROD and its CGC appearing for the respondent on account of, on the ground that he is presently in bereavement. Prayer is not objected. Learned counsel for the petition. Registry to in after 2 weeks on a date.
Your lordship, if it can be taken on the first week of May, your lordship.
Okay. Registry to list this matter again on 8/5/20.
Yes.
Can it be taken on 7th?
7. Okay, 7/5.
Readings are otherwise completed.
7/5.
Please, Your Lordship, my lord, yesterday I have filed additional affidavit in reply, my lord. It's
Where?
not on record, my lord. Item number 22, my lord.
That Burah.
Burah, my lord.
Yes.
May it please your lordship. Item number 34, my lord. In this matter, my lord, BTC has filed their affidavit today, my lord. So this matter may come up after vacations, my lord. I have already taken the consent from the petitioners, my lord.
Learned standing counsel. Have you informed the respondents
Yes.
also, counsel? Private
Petitioners, I have informed, my lord.
Respondents, they may have.
Actually, direction was given to the BTC authorities, my lord, to file their affidavit on or before.
Okay, we'll not pass any order. Let it come. We'll see.
Lordship.
Not a matter. Please.
Lordship.
We'll accommodate.
Lordship.
May it please, your lordship. Lordship, with regards to item number 20 of the daily list, your lordship, he had circulated an adjournment.
You're
request.
making this prayer on behalf of Mr. Ken Chaudhary.
Ken Chaudhary.
Personal inconvenience.
Lordship.
A prayer is made on behalf of Mr. Ken Chaudhary. Adjournment in the matter. The ground of personal inconvenience. Prayer is so made with the consent of the learned counsel for the respondents. So accordingly, the registry to list this matter again after 2 weeks on a date to be.
Lordship, if I may pray, the matter may be fixed for in the month of May, second week of May, your lordship. 12th of May.
For admissions on a date to be fixed by the petitioners in the by the registry in the second week of May. Yes, madam.
My lordship, I beg to mention item number 9, the matter
Item number
9.
9. Sorry, rejected.
The matter may be,
Rejected. Prayer rejected, madam. Once mother will file, then the son will file, then again the mother will come. What is this? Call your senior, ask him to come and argue. Yes, have you got that file?
Yes. Lordship, this file number SN 48 2012. Page 20.
How about details about page 21?
Have you got your instructions till when they were working?
So that is not formally they have not released.
You're not able to
But
touch.
they are still working in different ways. They are still working in different departments, but without any formal appointment or engagement. Somewhere also engaged with some minister,
13.
some MLA. This way they are utilized. Manpower has been utilized without giving any salary. Now, my lord, this file 48 2012, prior to engagement in against the 5 regular appointed daily wage worker, their salary was paid on cash. And
Lordship,
that salary
that
has
is the
been
salary
Mr.
slip.
Bhuya, we will come back to you. Yes,
Next page, Lordship may kindly see, they received salary till 31/1/2015. Thereafter, no salary loss. And Lordship, out of that 72 list, Lordship,
Hmm.
as on date, 47 are working, others not.
and in this list at page 22,
That is a list of 64. Their
Where
names
they
were
are not
there.
there.
But finance objected because their names were originally not there in that list of 120.
the names of the petitioners are there in page 22 and 23.
Were there forwarded by the department. But it,
64.
yes, but 64, Lordship.
Hmm.
But it was rejected by the finance, Lordship. That is the impugn in the writ petition, Lordship, saying that their names were originally not there in the 122 and 72. And it is the specific stand of the department. After 2015, they are not working. There is no question of paying any salary. Financial service. What is it? It's like
When was the date of your initial engagement?
Additional engagement, my lord, that is not on record, but this file will reveal, my lord, 48.
They are after 1493.
Yes.
After 1493.
And my lord, so far this record is concerned, the petitioner number 2 was working since, my lord, 2004.
Okay.
That is page,
Got it.
my lord, 30, my lord.
Anything more, Mr. Bhuya?
And my lord, so far salary statement is concerned,
15.
the petitioner number 1, my lord, I have enclosed here. document.
The issue, now it is clear from this file. There are two categories of workers. One who is there from prior to 1493 no finance approval is required. Others who came in after 1493, a finance approval is required. So for engagement of those people, a finance approval is. File was moved. This finance found that there are a lot of notings before that. Finance asked the SAD that from where have these people come up? What is the proposal? They said work was there, so we engaged. Then the impugned endorsement was made that these being engaged, there was an OM that these people, petitioners being engaged without the finance approval, they cannot be permitted to continue. Accordingly, the file was further processed and it was found that there was a note put up that institute departmental proceedings against those persons who have engaged them. Then the termination issue came in. Then the noting is that we have not even engaged them through a formal order. Where is the question of terminating their services? So just release them and you were released. And thereafter, the file proceeded with for that 59 people who were originally working with the concurrence of the finance department. Now from 2015 onwards, you are not getting salaries. There is no formal engagement in your case. You continue as you are continuing.
But Lordship, so far serial number 42 and 53 to 59, their name also not appear in the original list, but their salary has been enhanced.
Yes, what do you say on that?
This is the not fair, my lord. Equal pay, equal salary, Lordship.
127.
Yes, what do you say on that?
Therefore, my lord, one of
Lordship, so far as 42 to 57, 42, 53, 54, 55, 56, 57, 58, and 54. They were all there in the list of 120, subsequently in the list of 72.
But in originally 72, their name not placed.
But 120, they are there.
Lordship,
Where do you get that?
from the record itself, Lordship.
For me?
120 from the other. 72 खनर position बिला mark हो सर.
Lordship, may I submit one thing?
53 to 59.
53 to 59. 53 to 59, their name
नाम कितना कोई जान पे.
does not taken place in the original list of 72.
72 is still 120. 72.
Chief will see in that list, my lord,
Hmm.
the original list which was sent. Out of that, my lord, 53, which is who is Jitu Sharma,
Hmm.
is placed at 32 of the original list. 32. Can you see 32? Jitu Sharma.
Jitu Sharma. Then you have,
Jitu Sharma is there. He's 32.
then you have
Then we have
Bulendra
Bulendra
Dekka,
Dekka, he's 58.
58.
He's there.
Then
Then there
Utpal
is,
Saur.
my lord will see Girin Chandra Talukdar.
Hmm.
He's there at 56.
Hmm.
And you all will see, my lord, Hitesh Sharma. He's at 77. My lord. This 70, Hitesh Sharma has resigned actually. my lord. He's there at 77. Then your lordship will see Paresh Kolita, who's 59. He's 35.
And what about this Utpal Saur?
129.
The rest of the three, they are not them. Rest of the three, I could not find them. But these other five are there. my lord. One of them has resigned. No longer working.
Thirty-five. 35, it will be 35, 35. For a quad. Because no further, you go 35 and 30 Paresh Kolita had.
Utpal Saur is not there.
Original list. Original list.
কেটে না ফেলা.
নাম অরিজিনাল লিখতে পারছি 1 2 3 4 5 তার ভিতর 5 নম্বর জন
Let's say impugn,
হিতেশ শর্মা হিতেশ শর্মা
impugn or
এইটো কবিন
নাম নাই
15 to 2014.
অলসো অর্ডার নাম
Just find out Utpal sort for me.
এইকেইটা আছে নাই তিনিটা উৎপল নাই
But here in this page 22, 23, Utpal sort figures.
in the original I think 120 they were there.
Just find out. Anything more, Mr.
Lordship impugn order saying original list consisting 72. And so far, my lord, 42 and 53 to 59.
Hmm.
Regarding their name, there is no any indication in the impugn. Why? Because their name also does not take place in the original.
Okay. Mr.
And so far, my lord, this
Mr.
bank account statement is concerned.
Fukan. Chitu Sharma is that serial number? 32,
G2 Sharma 32 original list 120 list
120 list.
then Bulendra Deka
Why his name is not there in the 72 list?
Issue is 72.
Page 61.
for 72 lordship will have to see the original record lordship.
That's what I'm saying. In page 61, you just, Mr. Mac, just go through that, clarify it,
Lordship.
and then tell me. We'll take it up after some time. When you are ready, just tell Mr. Bhuya and tell my footmaster.
Otherwise, Lordship, I mean, if somebody has been approved also, Lordship, and on the basis of that, they are claiming that I should also have been.
No, it's not that. What they are saying is that you excluded us because of
Lordship,
non-approval.
one similar.
If you have kept somebody with that same deficiency,
Lordship.
why that benefit will not be extended to them when
My lord,
SAD says that they were required, so we have kept.
my lord, one similar matter disposed of, my lord, similar situated. So, my lord, so far our representative is concerned, that has yet not disposed of. And their reply saying that it is under process. 10 years already gone. But our representative has.
We are not in representation stage now. We are for the decision on merits.
Otherwise,
Either your way or his way. We'll not remand back.
Lordship.
So, just go through that. Give me that details. Two things. Why the 61, 64 list contains name of the 53 to 59
Yes.
when it is not there in the
Original
page 61 list, 72 list.
72.
Okay. 120, 72, then 64. Right? 3 lists are there. So if it is there in 120, why it did not come for in the 72? And it again came in the 64 list. Right? Just get me that sequence.
Lordship. When, Lordship?
After some time, whenever they are ready, they'll inform you.
Lordship.
Mr. Fukan, inform Mr. Bhuya, then we will take up. Mr. Das, have you gone through the,
I'm praying for further 2 weeks' time, my lord, for filing an additional affidavit to meet up the points raised by your lordship, my lord. If the actual petitioner, you are just a cancer patient, my lord. He was a medical treatment for a long time, my lord.
I know that, but in the writ petition, there is no.
No, for that, actually, I will have to file an additional affidavit, my lord. Let it be after vacation, immediately after vacation, my lord.
On the prayer of Mr. N.C. Das, Learned Senior Counsel, assisted by Ms. J. Boysha, Learned Counsel, assisting Mr. N.C. Das, Senior Counsel, appearing for the petition. Praise that. Further 2 weeks' time be granted to bring on record an additional affidavit with regard to for dealing with the queries raised by this court. Why the order dated 26/3/2026. Prayer is not objected to Y. Yasmin, Learned Counsel, appearing for the respondent bank. The registry to list this matter again on
Can it be on 123rd, my lord?
23.
22, my lord.
23 will do.
20.
23rd of April.
My
23/4.
lord.
Obliged, lord.
In this case, my lord, I sincerely pray for some more accommodation because of the fact that the board has to sit when the
We will pass the orders, then the board will sit.
no, my lord, appreciate for a while. The chairman of the board is a contesting candidate in the election. My lord.
Why disturb him? We will pass the order, then you comply.
Definitely, your lordship will pass an order, but if I may be given some time to
Why-
take a
why?
decision.
You can't take a decision. That was just a
lord-
observation made.
My lord, what is there, my
We
lord?
have to decide whether the termination was perfect or not.
My lord, there is an
That
admission on his
we have
part,
come-
I'm told. my lord.
We are all at IDM that the process adopted was clearly erroneous. There was nothing.
My lord, I was oblivious of one fact, my lord. There is a admission on his part.
Admission to what?
That-
Admission to what? Admission to what?
That he
You
made a
like
mistake,
that.
that he made a mistake.
Fine, but
And he was
No,
a
no, in
trainee man.
response
He
to
was on,
what did he
he
make
was on
that
probation,
admission?
my lord.
Mr. Chamuha, the admission in context of a departmental proceeding comes to a show cause charge. Where is the show cause? Where is the charge against him?
Chokos is there.
No, there is no show cause. Show me.
Yes, it's there, my lord. Yeah, I can produce it before lordship.
Ah, show
It's there, my lord.
show me.
Chokos are there, my lord.
Show me.
This one, this one. Lordship had gone through last occasion.
Short memory, that's the problem.
There are Chokos, my lord. I flagged certain documents, my lordship may go through those documents. And he was a trainee man. That is why, my lord,
No, I got it. This is there. But where was it served to him?
pardon,
When was it served to him? Where is the service of this?
he replied to this also.
Where?
That reply is not,
If it is not here, it is not there.
my lord, then my lord, on not being satisfactory reply, then the inquiry was conducted.
Where is that inquiry report?
And
Inquiry was in context of his suspension.
my lord may appreciate, he has.
As to why drastic disciplinary action should not be taken against you, including recommending for removal from service from so-and-so, submit satisfactory reply within 3 days, failing which the higher authority. So you have this. Where was it? When was it sub? Have you received this show cause? Any show
No,
cause? No. Where in your affidavit, where have you stated that you had issued a show cause to him?
My lord, I will come up with everything, my
No,
lord.
today.
And with a, my lord, concrete proposal, let the board be set for a while.
No, we are not concerned.
My lord, this is the election timing. That is why all the,
Election will go on. We don't have elections.
my lord, the chairman of the board is a
Let him.
candidate.
Let him.
My lord, will accommodate this for a while, my lord. Just after the election, we will come up with an.
Your case in para 12 is totally different.
Para 12 of my affidavit.
Affidavit.
Yes.
Page 67.
No articles of charge were framed, no list of witnesses, nothing. As such, no declaration, so and so, so and so, so and so. Was simply called for a personal hearing on 13/10/2015. Where is that notice, 13/10?
Is there, my lord. Personal hearing notice are there.
That-
Even it is in the writ petition also.
No, that show me.
No, writ petition is
Personal
there.
hearing.
Yes, my lord. It's there, my lord.
No. And page 41. The inquiry officer had exonerated.
No, he was not the inquiry officer.
Come to.
I got it. I have seen. He was not appointed as an inquiry officer.
Enquiry notice is in relating to your suspension.
Inquiry officer report is page 54 below. That
The
is,
writ petition.
yes, madam, of the writ petition. Chief automobile engineer, he was the inquiry officer.
Not examined, my lord. No report was furnished, my lord.
This is the report. My lord, these people are
Okay.
without having any legal background. Therefore, there may be some mistakes in the formatting of the records. But contents we have to see, my lord. He is a trainee man.
This is against that station supervisor, not against the petitioner.
No, my lord. This is against the petitioner also, my lord. Kindly see the page 54, last paragraph, my lord. It is also observed that this is not the solitary instance of such misappropriation of traffic money, adopting the same type of practice as above by Sri P. Sukhya, SSN.
SSN. That is not the report with regard to the petitioner. Now, there is nothing here to show that this notice that is there was issued to him. 8-6. From your record, it is clear. Inform you that personal hearing of Sri Putul Gugoi so-and-so has been done at this end on 13/10/2015. I am forwarding here with the related records in original discharged, duly discharged for favor of your necessary action. Page 41 is enclosed here. And it says that he is exonerated.
That is what this
Statement
man
is also there.
This man was never appointed as an inquiry officer.
Then why it is there in your report? Why in your?
I understand, it is there.
And where there is no other material here. There is no other material. There is not even a reply from the petitioner here. Okay. Done.
I sincerely pray, my lord,
No further time.
at least after 9th of April, my lord. Any date after 9th of April. But this is a genuine blockade, my lord.
Nothing you have got us.
I understand, my lord.
That is the end of the matter. But the learned counsel for the parties at some length, at length, hearing concluded, registry to list this matter on 8/4/2024.
Not 8/4, my lord.
8/4/2026 for delivery of it's for me. I have concluded the hearing. A record to Bhalket video.
My lord, can it be after 9th, my lord? One day, just one day, my lord. 8 and 10th is not a big deal, my lord.
8, 9, 10, we are holidays. We have heard it. We have heard it. We have heard it. We'll now pass the orders on merit. Then you take a call in your division, in your board, whether you got to go to.
My lord, there is an
The
admission.
other-
I flagged that document.
We will take everything on note. Don't worry. Whatever is there in the record, we will take it in. There is an inquiry report also in the record which exonerates him. We'll take that also.
And there's an admission also, my lord.
Admission, we'll accept it. But with the admission, he was exonerated. Then what is left? Enough. Keep one bus free for him.
My lord, reinstatement, my lord, I have no objection. That day also I submitted before lordship.
Reinstatement in the circumstances cannot be without some other
Yes, that my lord, that on that point, we need to take it.
I need not, we should not hear you on that. I
My
made a
lord,
mistake on that.
reinstatement, my lord, appreciate for a
I
while.
made a mistake on that. Mr. Sharma has paid for review of that. What I am reviewing it.
My lord, just allow me to submit, my lord. Reinstatement is within the power of the managing director. He said, tomorrow I'll do it. But to pay even a lump sum amount to that person, it needs an approval of the board. My lord. Since it is a financial,
No problem. We will put it, you go up before the board, take your approval. Approval not granted. You have a remedy of appeal. What is that? You go. We will find out some way out.
obliged. Wait,
Yes, what is your case?
If your lordship comes to page 23, madam,
This is regularization.
regulation and madam, we have challenged the select list, which we have been,
Where is that challenge?
on page 62.
Okay. So what are you pressing here?
Uh,
Regularization or the challenge?
But challenge, madam.
Regularization is not.
Regulation in the item number 6, madam. It is for regulation. This is regarding the selection.
You are still continuing.
No, my lord. They have asked me, my lord.
Okay. First, we'll take up this election. First, we'll take up
Madam.
this election.
My lord.
That is item number 6. Right.
5, madam.
6.
6, madam.
6.
Okay.
Okay.
6, madam.
Argue.
Lordship, Mr. P. Sharma, Standing Counsel for the Fishery. But I have a telephonic conversation with him. He's here. Will not appear.
Who appears for the respondent? What is your headache?
No, he called me, that's why, madam. Lord,
Matter is pending from
2017, madam.
17. Nothing more. Today, either way it will be. Yes, Mr. SP does.
Lordship may kindly come to page number 23.
Who are you?
But there are 7 numbers of petitioners, madam. We
You
are
were appointed initially under a scheme.
under a scheme, madam, for a period of 1 year. That you, Lordship, will find the advertisement at page number 23. To a proper selection procedure, madam, comprising of written test and interview.
What is that scheme?
The scheme, your Lordship, will find at page number 23,
23.
madam.
Scheme as a district.
District engineering consultant. My lord.
When were you appointed?
As per this, madam, we applied and madam, we are selected on the next page, madam, page 24. 24 is the select list, madam.
Where are you?
We are, my lord,
How many are there?
7, my lord.
Which are the people?
My lord,
All the 7 are here.
all the 7 are here, madam. Madam. If your lordship again comes to page number 23, the advertisement, that was for a period of only 1 year, madam. The engagement was for a period of 1 year only.
Then what happened?
Hereafter, madam, an agreement was executed between us
Hmm.
and the respondent, madam, Fishery Department, madam. That your lordship will find at page 26. Here in, madam, under TL number 5, it has been mentioned that required initially for a period of 1 year from the date of signing of the agreement. But in the advertisement, it was mentioned that service under the assignment is expected to commence from November 2006 for 1 year with the provision for further extension based on satisfactory performance to the consultant staff.
Up
But
to
this, my lord,
31/3/2010. Up to 31/3/2010. Okay, then what happened?
here, my lord, here are some clauses, my lord, in clause number 5, my lord, page 26, clause 5. Here the period has been mentioned, my lord. And in clause number 7, it says that we understand and hereby agree that in the event of decision of by DFDO to terminate the contract, 1 month termination notice will be served. But this was not served to us.
Okay, then what happened?
Therefore, my lord, we are appointed, my lord.
Oh, you
Yeah.
continued.
We continue.
How did you continue after 31/3/2010?
Our services were extended from time to time.
How?
But it was extended, my lord. That I have not annexed, my lord.
No, in the event extension of service is allowed, a letter from the DFDO so-and-so intimating about the extension and a written acceptance or thereof by shall have legitimate extension effect of this. Where are those letters?
Those I have not annexed, my lord.
Where are those? Have you made a statement?
Yes, my lord.
Where? Show me that this was being
But
extended.
lordship, if your lordship kindly comes to page 28, it has been mentioned that the period has been mentioned. Page 26.
Oh, this we are not considering. Show me how the
A paragraph, my lord.
show me how your services were engaged, because this contract
My lord.
dies it death with effect from 31/3/2020. Contract entered into in 2007
My lord.
expires on 31/3/2010.
Yes, my lord.
After that, how were you continuing?
But we are not extended, my lord. Our period were extended from time to time. Clearly, my lord.
No agreement, no order.
There must be some order, my lord.
Ah, where are those? That has to come here.
My lord, that I have not annexed here, my lord.
Then that means there is no material available on record.
Materials are there, my lord. Materials are there. That's why we are serving, my lord. Now, lordship may kindly come to page 28, my lord.
28, yes.
28 to 8. A decision certificate issued by the authority, my lord.
Yes.
This is a certificate issued by the authority, my lord.
This is Ajit Rai's petitioner number
I will
6.
check. It is to certify that so-and-so who rendered his service as district engineering service under the World Bank Aid Assam Agriculture Competitiveness project in the office of the district fishery development officer.
Okay. This advertisement was of 28/9/2006.
Yes, ma'am.
How could you be serving from January 2006?
Yes, madam. Yeah, Mr. Thinking. But your lordship kindly see the next page, that is from January 2007. Next page.
That I know, but what about this
This one.
Ajit Rai? How is he serving from January?
This may be
When this scheme came into being only after
28
in 2007, that too after 19/1/2007.
advertisement was issued on 28/9/2006.
So you are engaged from
January.
January 2006. How is that?
Timing, Mr. Madam. Maybe. But
Oh, so wherever there is a problem, it's a timing mistake.
next page is
Where have you clarified? That is in regard to somebody else.
But
Where
it
have
is-
you clarified that in your report?
that I have seen just now.
Then, next.
Next page, lordship.
Hmm.
Lordship, this is Rumini Kumar Nath.
So how is it extended after 31/3/2010?
Their services were extended from
Certificates cannot be given anywhere. Focus. Yes, next.
these are the certificates, my lord, for the employment, my lord. Hereafter, my lord, lordship will come to page 34.
Hmm.
Page 34, my lord. This is the termination notice.
Okay, so your services came to be terminated
My lord.
with effect from 31/3/2015. So
Yes.
we accepted.
Yes, madam. But I am obliged, my lord. But this termination notice was issued without serving us a notice of the 1 month.
There is no contract.
My agreement was
There
there.
is no contract.
initially.
The contract agreement has not been continued.
but it
You have not
was-
shown.
But it continued, my lord. That's why they have written with reference to the above, my lord. I am to inform you that so-and-so will post on so-and-so by the project so-and-so. Hence, as per the direction of authority of services, as
Okay, what did you do after this?
after this, my lord, we, without having any alternative matter, we approach the honorable court.
When?
My lord.
Any writ petition filed
Yes, madam. Many, my lord. Not one.
against this order?
Yes, madam.
Where?
The first petition was filed. The lawsuit will find at page number 44.
44.
My lord. It starts from 43 to 44, my lord. Yes, madam, we are,
No, Mr. Das, what I'm asking you is, you were terminated on 31/3/2015.
Hello.
Where is the writ petition assailing that?
but,
This is something else. This is junior engineer selection.
my lord, to relax, since the advertisement was
So
issued,
why are you clubbing issues? I'm asking you. You were terminated.
my lord.
Where is the challenge to that termination?
But this was not challenged, my lord.
This was not. Now let us see
This
your
was not-
prayer. Okay. Not challenge.
So, my lord, after the termination, my lord, notice, they issued the impugn advertisement at
Where
page,
is that at?
page 41.
41.
This we have challenged, my lord.
Fine. 2415
215.
advertisement
Malad.
and educational qualification for
So, my lord,
preference will be given.
my lord. PL number 2, my lord, junior engineer, civil, under fishery department. Here, my, in the advertisement, it says, preference will be given to those candidates having experience
Okay.
in execution supervision.
What does
of-
this court say in this order?
In this case, my lord,
Age relaxation.
my lord, yes, it is, sir. But this preference was only for us, since it has a mention here that it is for the persons who are working under the fishery. Those are we, my lord.
Huh.
Yes,
Right.
yes, my lord. Now, my lord, the question is how the preference process is to be used. Where,
That will come.
where before or after?
Then what happened?
We made a challenge to this, my lord. Thereafter, my lord, for relaxation of the age, we filed this WPC, my lord, at page 44, 43, 44.
Relaxation granted.
Granted, my lord, granted. Thereafter, again, one petition was filed at page 54 regarding weightage.
Now, you came up before this court, then another set, Utpal Chakraborty is
Yes.
also a party here,
Yes, my lord.
page 54,
My lord.
Huh?
My lord.
wherein these very grievances were raised,
My lord.
right?
Regarding, my lord, regarding the weightage. If your lordship comes to page 57. 57.
Read that
My
para
lord,
8.
my lord, there was an observation that
You read para 8.
para 8, yes, my lord, that one. The Learned Council for the rival parties submits that the selection process through written test is due to be held on first week of June 2017, and in that view of the matter, keeping the case pending is found to be not necessary. In that view of the matter, the writ petition is disposed of with the observation that the responding authorities concerned shall abide by the terms of the reference as provided in the advertisement to the effect that the preference will be given to those candidates having experience in execution of supervision of the civil work under the Fishery Department. However, it is made clear that such preference can only be availed by the writ petitioners and those who are alike if they are successful in the written execution to be conducted.
Yes.
Now, since this honorable court had made an observation that if we are successful in written examination, will be the preference will be granted. And this order was again challenged by way of a review.
That was recalled.
Now, yes, this paragraph has been recalled now. That is at page number, page number 50.
Then what happened?
Thereafter, madam, as per
Your names were not shortlisted.
not for this step.
That's the only case. Now show me.
Now, madam, the preference clause which was given in the advertisement,
Yes.
that has not been given to us.
Okay.
Now, madam, Fishery Department has not filed their affidavit.
Forget the affidavit now.
Madam. But APSC has filed their affidavit. People is- My affidavit filed by respondent number 3. But the respondent number APSC has filed their affidavit. Herein, they have mentioned at paragraph number 4. They have mentioned that they have put an cut-off mark.
Yes.
Now, Lordship comes to the page number 3. The marks obtained by us have been mentioned, madam. And their statement is that since we failed the written test, so we are not called for the proceeding. At paragraph number 5.
Yes.
Madam.
That much only.
This much, madam.
Okay. Any case loss?
Yes, madam.
Yes.
Lordship, I have given the
93, 2.
madam.
Dilip Kumar.
Madam. Lordship may kindly come, madam. Serially, madam.
Dilip Kumar.
Madam. But that tilting factor is here, madam. That tilting factor. That tilting factor.
Tilting factor.
Madam. That is.
Leading
When is to be used, madam?
Leaning pizza.
Yes.
Leaning tower of pizza. Where it will lean now.
Madam. Yes, madam. Where in the starting or at the end? Lordship may kindly come to first madam, 2006 SEC. Paragraph number 18.
These judgments have now been interpreted in a different manner.
Yes, madam. That I understand, madam. But the thing is that this difference should be counted at the last point. Who is
Last
combined?
point when everything is equal.
Yes, madam. As per the advertisement, the preference was given to us, and that was not taken into consideration, madam. Madam, kindly come to paragraph number 18.
You read para 16.
Yes, madam. This is also there, madam. This court has consistently held that when selection is made on the basis of merit, access to the competitive examination and interview, my lord, and interview, preference in additional qualification would mean other things being quantitatively and qualitatively equal. But only after interview, my lord. I am on that
Okay.
point, my lord.
Done. Accepted.
Now,
Yes.
my lord, paragraph 18.
Huh?
18 also, my lord, 18. Paragraph 18.
This is the lead case.
My lord, yes, my lord. The mid-person, my lord, the procedure for selection in the case involves a qualifying test, a written examination, and an oral test or interview. And the final list of selection has to be on the basis of marks obtained by them. This was denied to me, my lord.
That means you say that you fail, don't achieve the cutoff marks,
Madam.
still you will have to be taken to the
Yes,
interview.
madam. Yes, madam.
Now, in the interview, you still don't come within, say, the merit position. Still, you will have to be given. Is that your case? Then what is the question of you having a selection at all? You should be given en bloc.
No, no. And block is not permissible. As
Now,
mentioned
now
by the
tell me, what
court.
is your take? How will this preference be given after the selections? Say, allow you to participate in the interview. Now, what the APSC will do? How will it prepare the select list?
Well, as per this judgment, what I understand,
Forget the judgment, bomb the
What I understand,
judgment, what
madam,
you have understood,
that-
take yourself.
yes, madam. The preference should be given at the last point.
Last point.
Last point, madam. After written test and oral
Okay.
or
Now,
viva voce,
a person has not qualified in the
written test.
written test, he will be allowed because he is under that preferential
Yes,
category.
prefer. I worked
Appear
for
in the interview.
17 years.
You didn't work. Okay.
17 years, madam.
You come to the interview, you sit in the interview.
Madam.
Now you say that there is 100 marks in the interview, you are given 10.
Madam.
And you are placed out of 1,000 candidates, you are placed at 999. How will your case be considered?
Automatic, madam. They have,
Will be out?
yes, madam. They automatically look out.
Then how much should you
They
get to
have
come in?
denied that, madam.
Oh, got it. Yes.
But there are some more judgments, madam. My second one is, madam, 1993 to 60, madam.
Dilip Kumar.
Yes, madam.
Different
Paragraph
factual.
13, madam.
Huh?
Paragraph number 13.
Huh?
Paragraph number 13, madam.
13.
Page 323, madam. Here also, madam, it says, madam, only after the complete process is over, then preference will be counted as a tilting factor, madam. They have not given me the opportunity to sit in the madam, interview, madam.
Okay. Noted.
Madam.
Next.
Next is, madam, 2003 5 SCC, madam. Madam, paragraph number 10. It says, madam, the procedure for selection in case involves a qualifying test, a written examination, and an oral test interview.
This is Srinivalu. So
And the
para
final
10.
list,
This
student
is
has-
para 10.
Madam, 10. No.
Then that is recorded in para 18 of the first judgment.
Yes, madam. Yes, madam.
Then
Absolutely. And madam, 2007 11 SCC, paragraph number 18, sorry, madam, 16.
Yes. Then
Then, my lord,
Sapna.
2016 for GLR 25572. Notice also appear in this case, my lord. At para 7 and 8, my lord. And the last one is, my lord, 2005 for SEC. Here it says about the procedure. Once the advertisement is issued, there cannot be make any sense, madam.
Show me.
Paragraph number 11. There are two principles in service which are indisputable. Firstly, there cannot be an appointment beyond the
Para-
advertisement.
para-
Paragraph number 11.
10.
Madam, mine is different, madam. The printer is different, madam. It reads as, madam. Firstly, there cannot be an appointment beyond the advertised number, and secondly, norms of selection cannot be altered after the selection process has started.
This is on a different context of
Yes, madam. Yes, madam.
excess vacancies. Anything more?
No, madam.
Yes, ma'am.
Lordship. Lordship, our advertisement, Lordship, at page 41. It has been stated in the advertisement that preference will be given to those candidates having experience in execution or supervision of civil works under Fishery Department. Thereafter, in page 42, Lordship, it has been mentioned that in case the number of applications received is large, the commission may shortlist the number of candidates either on the basis
You're reading clause?
towards the bottom of the page, Lordship, clause C, written test. Point number 2, Lordship, by holding screening test, which will be notified in due course. Thereafter, the screening test was held, and the petitioners have failed to secure the cutoff marks in the said screening test, Lordship. The preference will, the point of preference will come at the time of finalizing the
After
result.
clearing, if there are many candidates who are having the same marks,
Lordship,
then the man
Lordship,
with the preference will go up.
Lordship. That is my submission, Lordship.
Yes, madam. The others have been appointed. Private respondents?
Yes, sir.
Initially, there was a stay, madam. Initially, there was a stay, madam.
That was vacated.
Vacated.
Our role is very limited, Lordship. As per requirement, we have sent the APSC, Lordship, for conducting the test, Lordship. So as per the select list that has been provided by the APSC, the government has appointed, Lordship.
When was the select list published?
17/10/17. Page. Page 67, Lordship.
Okay. Heard Mr. S.P. Das, Learned Counsel for the petition. Also heard Ms. M.S. M. Bhattacharjee, Learned Additional Senior Government Advocate, hearing 40, 1, 2, 4, and 5. Also heard Ms. P. Sharma, Learned Standing Counsel, some Public Service Commission, hearing 40, respondent number 3. The present petition has been instituted by the petitioners, presenting a challenge, a select list dated 17/10/2007, published by the APSC in pursuance to a written examination held in terms of an advertisement dated 8/2015, dated 2/4/2015 for the post of junior engineer, for 32 posts, vacant posts of junior engineer, bracketed civil, under Fishery Department. The petitioners herein, who were earlier engaged as district engineering consultants, bracket fisheries, in the Assam Agriculture Competitiveness Project, aided by the World Bank, had submitted their respective applications in pursuance to the said advertisement. Also, the applications submitted by the petitioners being found to conform to the eligibility criteria set out in the advertisement, the petitioners were called for a screening test. Also, in pursuance to the said screening test, the submitted their applications. Also, the petitioners, having found that they were beyond the maximum age limit as mandated in the advertisement for applying against the post of junior engineer civil, under the Fisheries Department, in pursuance to the advertisement dated 2/4/2015, had approached this court by way of instituting a writ petition number 3750/2015, praying for relaxation of their overage. Also, a coordinate bench of this court, wide judgment dated 4/9/2015, on considering the submissions advanced in the matter by the parties to the proceeding, proceeded to dispose of the said petition, requiring the respondents to consider the case of each of the petitioners for relaxation of their respective overage on their individual merit. Also, it is seen that in pursuance to the said direction, the respondents had proceeded to condone the overage of the petitioners herein. Also, the petitioners at that stage had also instituted WPC number 8026/2015, praying for an appointment against the posts as advertised, while the advertisement dated 2/4/2015. This court, according to the bench of this court, wide order dated 22/5/2017, appoint them so and so by extending to them weightage for the services rendered by them as district engineering consultants, bracketed fishery. The coordinate bench of this court, wide order dated 22/5/2017, Dubar Recidive, Agot to Katiriba 17, proceeded to dispose of the said petition by observing that the respondent authorities shall abide by the terms of reference as provided in the advertisement, to the effect that a preference will be given to those candidates having experience in execution of supervision of civil works under the Fishery Department. However, the coordinate bench, by the said order, also stipulated that such preference can only be availed by the petitioners and those who are alike, if they are successful in the written examination to be conducted. However, the later portion of the observation as made by the coordinate bench of this in the said order, on a review application being filed, being review petition number 115/2017, being instituted by the petitioners, the coordinate bench, wide order dated 28/8/2017, proceeded to recall the later portion of its observation as made in the order dated 22/5. So thereafter, the respondents, thereafter the screening examination having been held, the results thereof were declared on 26/9/2017. Also, the names of the petitioners not being included in therein, have instituted the present writ petition. Mr. S.P. Das, learned counsel for the petitioner, has submitted that although at the outset has submitted that although a prayer for regularization is made in the present writ petition, he would not press the said prayer inasmuch as a similar prayer is also made in WPC number 4342/2018, which is also pending disposal before this court. He submits that he would limit the present writ petition to the challenge to the select list dated 17/10/2017. A select list dated 26/9/2017.
27/9, madam.
26. It was published on,
27.
but the select list declaration is on 26,
Yes.
declared on 26/9/2017 and
20.
published on 27/9/2007. Mr. Thus, by referring to the advertisement dated 2/4/2015, has submitted that in the said advertisement, a provision was incorporated towards grant of preference to those candidates having experience in execution of supervision of civil works under the Fisheries Department. He submits that the petitioners, having worked with effect from 2007 to 2015 as district engineering consultant, fisheries, they are covered by the preference clause as incorporated in the said advertisement stands attracted to their respective cases, and accordingly, the same was to be reckoned by the APSC authorities while conducting the said selection. He submits that this court, that a coordinate bench of this court, wide order dated 22/5/2007, passed in WPC number 8026/2015, had also mandated that the respondent authorities shall abide by the terms of preference as provided in the advertisement. Reference as provided in the advertisement to the effect that preference will be given to those candidates having experience in execution / supervision of civil works under the Fisheries Department. Mr. Das submits that for the purpose of giving full effect to the said preferential clause to those candidates to whom the same stands attracted, the candidates concerned must be permitted to take part in every stage of the selection process. Also, he submits that the APSC authorities, in view of the said preference clause being incorporated in the advertisement, ought not to have excluded the petitioners from the purview of the selection process on they not achieving the cutoff marks in the screening test. Also, he submits that the petitioners were required to participate in the selection process further, and it was only after the completion of the viva voce and the computation of marks there that it would have been permissible for the respondents' authorities to exclude the petitioners from the select list in the event it was found that the marks scored by them in the selection process was not equal to the marks so scored by the candidates who were now incorporated in the final select list. Accordingly, he submits that the exclusion of the petitioners at this stage of after the stage of the screening examination had caused prejudice to interest, and the same was also in violation of the categorical provision with regard to grant of preference as made in the advertisement dated 2/4/2015. In support of his submissions, Mr. Das has relied upon the following decisions of the Honorable Supreme Court. Now, you don't feel 1, 2, 3 courage. Mr. Das has further relied upon a decision of this court in the case of the governing body Assam Jyoti Junior College versus Indira Devi and 4 others, reported in 2016 for GLR 572. It was one. Also, in the above premises, Mr. Das submits that the select list in question would mandate an interference from this court for further direction to the respondents to redo the selection process afresh and permit the petitioner's hearing participate in the viva voce segment of draft to finalize the select list, to publish the select list. Per contra, Ms. P. Sharma, learned standing counsel. You have nothing to say, Will. Say you have adopted. You are only Ms. M. Bachaji, learned additional senior government advocate, has submitted that the department had only proceeded to effect a point against the advertised post basing on the checklist as prepared, as punished by the APSC authorities upon conclusion of the election process held in pursuance to the advertisement dated 2/4/2015. Also, next, Ms. P. Sharma, learned counsel for the respondent for the APSC, standing counsel APSC, has submitted that in pursuance to the advertisement dated 2/4/2015, the application submitted by the petitioners being found to be in connivance with the eligibility criteria set out in the advertisement, the petitioners were issued with call letters requiring them to appear in the written test. It is called written test, not screening test.
Not screening test.
Written test in the written test. Also, they said written test, written examination, screening test. Written examination, screening test was held on 4/6/2017. Also, thereafter, they said the results of the sets written examination, screening test was declared on 26/9/2017. Also, she submits that the APSC authorities had determined a cutoff marks for the various categories of candidates appearing in the said selection process, and the said cutoff marks was further so determined pertaining to male/female candidates. The petitioners who are all male candidates belonging to general/OBC/MOBC community, for whom the cutoff marks was determined at 60 dash above 6 bracket for general community, male, and 52 for OBC/MOBC-male had secured marks lower than the cutoff marks. Accordingly, the name of the petitioners were not shortlisted for the viva voce component of the selection process, which was scheduled to be held on 4/6/2017. She submits that the names of the candidates found to have secured marks above the cutoff marks were included in a in a list published by notification dated 26/9/2017. Also, she submits that the projection she further submits that the projection made by the petitioners in the present writ petition that the preference as stipulated in the advertisement would be so applicable only in the event a candidate who had successfully cleared the various stages of the selection process was found to be quantitatively and qualitatively placed quantitatively and quantitatively or qualitatively placed with other candidates who is not eligible for being extended with such preference, and in such a situation, the candidate who is entitled to the preferential treatment would be preferred before the candidate who were not liable to be extended with such preferential treatment. She submits that the petitioners not having cleared the written examination, the stage for application of the preferential qualification in their respective cases did not arise, and accordingly, the above did not arise. She submits that only on account of the incorporation of the preferential qualification, the petitioners cannot claim that the marks scored by them in the written examination of screening test was required to be ignored, and even if it was found that they had scored marks lower than the cutoff marks, they were required to be allowed to participate in the viva voce segment of the selection. She submits that if this argument of the learned counsel for the petitioner is accepted, then the same principle would also be required to be applied while preparing the final select list, and therein, in spite of the fact therein, even if the petitioners have not secured marks within the merit position requisite for inclusion in the select list, even by after considering their reserve category status, the petitioners must be required to be included in the select list. She submits that the same cannot be the purport of a selection. If the set position is to be adopted, there would be no requirement for holding a selection in respect of persons like the petitioner, and they ought to be appointed by the department by only reckoning the preferential qualification possessed by such candidates. She submits that the set submission of the learned counsel for the petition would not mandate an acceptance by Ms. Any decision?
No, Lordship.
In the above premises, Ms. Sharma submits that the claim made by the petitioner present would not mandate an acceptance by dismissed.
Lordship, in the paragraph where having found their applications in consonance with the requirement of the advertisement, there is another point. Their ages have been condoned by the
I've said
government.
that afterwards. I've said that.
But
That-
item number 5 is there. 5. 5 only, but 1 point, my lord. Lordship may kindly come to page number 76. Well, everything has been mentioned. We filed an RTF application before the authority.
Where is para 5?
What?
Para 5 is what?
No, my lord. Kindly come to page 77. Sorry, 76. What the petitioner asked him, my lord? Page 76. We filed an RTF application before the authority. They have informed us that, my lord, next page, my lord, page 77, that there are still now 9 posts are vacant, my lord.
Oh, এটা লিখি দিবা এটা SP Das. Finally, yeah. Mr. SP Das, by referring to an RTI reply, has submitted that there are still 9 vacant posts of 9 posts available with
Junior engineer.
of the amongst the posts so advertised, why the advertisement dated 2/4/2015, lying vacant, and the petitioners herein
Lordship may kindly
being
note the
number,
date,
being only 7 in number, can be directed to be accommodated against the said post by reckoning their preferential qualification. Yes.
They have already been terminated, Lordship.
Yeah.
And this is of subsequent 2018, Lordship.
What?
This RTI reply, what they have obtained is of 20.
Where is that RTI reply?
Page number 76.
In your writ petition?
Yeah, my lord.
Huh?
Just
Item 5.
In the second
Item
one
five.
or this one?
Item 5.
WPC number 4342.
Ah, that is what.
76, my lord.
In 2015, they were terminated.
Again reappointed.
Anyway, it's of 2018, Lord.
Right, right. 76 and 77, my lord. Page number.
Amongst there are 9 vacant posts of so and so molecular. Amongst two now like. It is not said that it is out of
Not
that.
checked,
but
not checked, so, my lord.
9 posts of is it last of committee body.
But it has been mentioned as
Only-
junior engineer.
It's that in terms of the RTI reply dated 18/1/2018, there are still 9 vacant posts. There are 9 vacant posts of
Junior engineer.
junior engineer bracket civil available in the fishery department, against which the cases of the can be directed, considered for appointment by only treating their preferential, by only reckoning their preferential qualification possessed by them. Yes, now 4342.
But everything is same, my lord. Everything is same, my lord, except this, my lord, RTI, my lord. And my lord, we have also made a prayer to connect this case since a similar case is pending.
That will take care of itself, but this is now before me, I'll have to consider it.
Now, one more thing, my lord. This petitioner was again reappointed on 2018 and work up to 2024, my lord.
That is something beyond this.
Beyond this. That has not what we have, my lord. They are utilizing our services, my lord. It goes to 17 years, my lord.
Yes, any decisions you want to rely here?
In this case.
No.
Not what, my lord.
Only on the count that you were working in a project,
Yes,
you
ma'am.
want a regularization. And you were terminated in 2050.
Yes, my lord.
Dismissed. Get the orders next week.
My lord. Obliged, my lord. For giving a patient hearing, my lord. No, hearing. Oh.
Like, when I agree. What happened to the criminal case against you?
My lord, it has been already FR case, my lord.
FR.
It has been already. The patient has already got acquitted, my lord. By this order. Advertisement, I have been filed, my lord. মানে advertisement হিদিনা single হিচাপত দিছো না free দিছো কোৱা নাই বাৰু
My lord, last occasion it was directed, my lord, most of perhaps, my lord, to file by way of affidavit, my lord.
Huh?
Last may pay to the last order, my lord.
They have not. You're for the private respondent.
Yes, my lord.
Take your seat.
My lord.
Yes, what is your case?
My lord, it is an appointment of Gaura, my lord.
That much I can also understand.
My lord.
What is your ground for?
My lord, my ground is for my lord. In the affidavit filed by the circle officer on behalf of additional deputy commissioner, my lord, he has already stated that on the resident ground, my demand is justified, my lord, for para number 11, my lord. And in the
You're not
advertisement,
working now. You're working.
Yes, my lord, I will be under suspension, my lord.
Or subsequently.
My lord.
There is a conflicting, I have instruction that it stated that.
He is under suspension. That is his affidavit. That in affidavit also it says. But the allegation against you is very serious.
My lord.
Why are you keeping him in service? Why no proceedings have been instituted, Ms.
My lord.
Pachaji? He is alleged that his father was a Burah, and he has been rampantly issuing certificates of residence, identity, using the name of his father's signature seal, even after the death of his father. And you are not.
No, I
we
am
don't
not, my
find
lord.
you.
The petitioner, my lord.
It's a petitioner, not
Yes,
my
my
lord.
lord.
that was the allegation on which I was got acquitted, my lord, from Lanark Court, my lord.
Oh, FR.
Apartment.
Okay, on the date when when the thing had gone for a police verification, the case was pending.
No, my lord.
Case was, you were acquitted
Acquitted, my
on
lord.
that day.
My lord, case was after that, my lord.
Subsequently, my lord.
Subsequently, later on, my lord.
Or later on.
By someone's conspiracy, police lost the affair,
My
my lord.
lord, their case is based upon the only thing that I am the outsider, my lord. That is their case, my lord. However, my lord, if lordship may peruse the
What is the allegation against you?
My lord, he has all.
present allegation, my lord.
Hmm.
The present allegation, my lord, some misappropriation of fund, my lord.
Several
My lord.
allegation, my lord.
How some? How much sum?
I mean, it's 100, 200 rupees, my lord.
Fully.
My lord. Well, when I am issuing the certificate, my lord, I took 100 rupees, my lord. That is the allegation.
Okay, give me the dates.
My,
Yes, give me the dates of the advertisement.
that's my lord. Advertisement date, my lord. 22/8/2013, my lord. Advertisement date,
Advertisement for Burah
my lord.
in
22/8/2013.
Burah, which charge lot?
পহি জুৰিয়া ৰাজচক্ৰ অন্তৰ্গত জুৰিয়া মৌজাৰ দলনি জুৰিয়া লাট কিচামত
Juria?
জুৰিয়া মৌজাৰ দলনি জুৰিয়া লাট কিচামত
If lordship may permit, lordship, may I point out one thing, my lord. My lord, there is one thing may necessary, my lord. My instruction may required, my lord, in this case, my lord, from the government respondent, my lord. My lord, what happened, my lord? The advertise is issued there specifically that, my lord. If lordship may peruse the advertise, my lord, from the bottom, my lord, fourth line, my lord, it was that the abedonkari ukto lator sthayi bakhinda hobo lagibo. Lot, my lord. The lot number was 9, my lord. That in the lot number 9, my lord, there is a 4 village, my lord. 4 village is that, my lord. One is
Mr.
my lord.
Please have your seat here.
My lord, lordship.
Matter is pending since 2015.
No, my lord. There is
We will see. We will see. We
My
will take you first. Let me get over with him. Then I'll come to you.
my lord.
Where is the advertisement?
Advertisement
Not annexed.
not annexed, but I have filed it separately, my lord.
Where have you filed an additional affidavit?
Not till date, my lord, but last occasion I have filed it separately, my lord.
Boloni, Zuriala. Hmm. Yes, then interview,
Interview was
2811.
28th, my lord.
Then what happened?
Yes, got selected, my lord.
You got selected.
No, my lord.
Where is that material? You say that you secured the highest mark.
My
From
lord.
where?
My lord. Page number, Annexer A, my lord, page number 22.
Page number
22.
20?
22, my lord.
There is no 22 here. Annexure A. Annexure A is 12.
Let me- Impugn order, page number 18 to 20, my lord. Eighteen to 20.
Huh?
18 to 20, my lord. 20, Annexer D. Annexer D.
That is the appointment of the respondent.
Respondent, my lord.
Okay, show me that how you are contending that you were the you are not contending that you are the serial number 1 candidate. You are only contending that he is not a resident within that lot. That's all.
My lord, in this petition, my lord, I have claimed, I have a prayer to my lord, kindly go to my prayer portion, my lord. Page number 9. Upon causes being shown by the respondent and on page of the records, including reports of the concerned authorities and interview results, my lord. I demanded for that, my lord.
Okay, let us see your statements.
My lord. I would like to point out one thing, my lord.
Yes.
My lord, kindly go to the next page of the advertisement page, my lord. There is another report, my lord, by the circle officer. My lord, বিষয় জুৰিয়া মৌজা দলনি জুৰিয়া লাট কিষাণপথৰ গাঁওবুঢ়া অৱসৰ লোৱা খালী হোৱা উক্ত লাটত নিযুক্তিৰ বাবে লোৱা আবেদনসমূহ. My lord, there are 11 candidates who has applied for that post, my lord, and respondent number 4 has not been included in that list, my lord. That means, my lord, he has not applied for that post.
Permitted you to bring it on record. You have not brought it on record. So we are not concerned.
My lord, consider one thing, my lord.
Nothing. What is there, I'll consider. Because we already gave you. You did not take that opportunity. Anything more?
My lord, my lord, connected.
What is the marks you scored in this?
My lord, I don't know, my lord. That person I
You have not put in a RTI in that respect.
My lord, several RT has been done, but
Where do I get it?
till date I could not get that.
Okay.
My
It's
lord,
not on record.
not on record, my lord. My lord, kindly go to my lord, miss case number 70 of 2023, my lord. In that case, my lord,
What is it,
miss case 70 of 2023, my lord.
70 of 22.
2023. Page number 9, annexure 02, my lord. Report from circle officer, my lord.
Page?
Page 9, annexure 02, my lord. The next page, my lord, page number 10, there are several allegations against the respondent number 4, my lord. He has conducted an inquiry report, my lord.
Anything more?
My lord, I may be allowed to the advertisement report and the report by filing an additional affidavit, my lord.
50,000 cost.
My lord, on that last occasion,
You did not comply. 50,000.
my lord,
You pay 50,000.
it was my
Up to-
fault, my lord. My
Then-
mother
then-
has been on bed
No.
institution, my lord.
That order is very clear.
That's why I could not file that,
My Lord Justice Burah's order. It's very clear.
My lord, I could not file that due to my mother illness, my lord. I had to go to my native village, my lord.
21-2. This order is of 21-2.
My lord,
We are
my lord,
1 month around 10 days thereafter. I'm sorry, I'm not accepting.
my lord, her leg has been broken, my lord.
Nothing doing.
That was-
Yes, you pay the cost, you take 50,000. Yes,
My lord, this revision only, my lord, is the ground that my
now what is your material to show that you are a resident of lot, Toloni Zuria lot?
lord, it is my statement, my lord.
Where is the material?
Even
Where is
my
your land there? Land details. Land details.
My lord, land details. I have to need time sometime. Even my lord,
2015, that was the document you should have brought on record. You're
My-
interfering with your appointment also.
my lord, we,
You're asking the government to go for a fresh appointment.
my lord, we recently, my lord, we submitted an RTA application, my lord, whether under lot number 9, who is village at the lot number 9 is allotted.
I'm
my lord.
sorry, you should have brought the document on record. You have not brought the document.
No, my lord. My lord, what our presumption is that, my
You
lord,
cannot have. He has made an allegation. It was for you to meet. You have not met that allegation.
my lord, there is also subsequent development also, my lord. Let me point out, my lord. What happened, my lord? This petition was dismissed on the year of 2017, my lord.
Look at it. We have got
My
it.
lord,
Now the
after-
petition is
after
back on
the-
records.
After the, my lord, dismissal, my lord, another person was appointed, my lord, in that lot, my lord. What they have challenged, my lord. Presently, he is running this.
Then
board,
how,
holding
where
the
you
post
were
of
not
the company.
appointed in that lot?
No, my lord. I'm in different lot, my lord.
Show me.
Yes, my lord. Not should be in my affidavit, my lord. That's page 32, my lord.
Hmm.
My lord, this is my lord. I am presently, my lord, holding a Sotian place, my lord.
So where is your advertisement to this, for this recruitment?
Well, that is under the same advertisement, my lord.
Where? Advertisement, that is only for one post.
My lord, yes, my lord, only for one post, my lord.
Then how can they,
My lord,
that
initially-
advertisement give you appointment
initially-
in a lot other than Dulia,
No, my lord. This is,
Dulia, Juria?
this is, my lord. What happened, my lord? The lot number 9, my lord, there are containing on 4 villages, 4 numbers of villages, my
The
lord.
week we will not understand it in that. I'm sorry. That means there is some problem with your appointment.
Lordship, may once
Chopra, Antargata, Juria Moza, Doloni, Juria, Lot, Isamotor, Gaon, Burah. Only one. Mohammed Abdul Mannan Burah, Prithvi Mannan so Ali, অৱসৰ লোৱা খালী হোৱা উক্ত লটৰ নিযুক্তি পোৱাৰ বাবে স্থানীয় যুৱকৰ প্ৰাৰ্থীৰ পৰা আবেদন পত্ৰ বিচৰা হৈছে. That means the lot which was vacated
Yes,
by the father of. You're not there.
well,
Show me your selection.
my lord, yes.
You're not there.
My lord, they even, my lord.
You're not there.
No, my lord. My name also, my lord, is Lordship.
Where?
Yes, my lord.
That is why in the shortlist your name is not there.
No, my lord. My name is there, my lord.
Yes, madam, what is all this?
They are read petition, my lord. Annexure B, my lord. Page number 16, my lord.
Page number?
Page number 16, my lord. 16.
16. Okay.
Vernacular, my lord. Serial number 6, my lord. This is my name, my lord.
Nazrul Islam.
Yes, my lord.
Parik,
My lord, what happened, my lord? What my lord petitioner produced before your lordship, my lord? Lordship may once may look into my lord that documents, my lord. In serial number 6, my lord, 2 names have been repeated, my lord. In that forwarding, my lord. If lordship may peruse this, my lord, in serial number 6, my lord, Khalilur Rahman, and my lord serial number 1, he is also Khalilur Rahman. Both are same person, my lord. Subsequent to that, my lord, my name forwarded, my lord.
where is the appointment of the where is the RTI appointment? You received the appointment of the private respondent.
My lord, page number 20, my lord. Page number 20, my lord.
20.
My lord.
Okay. So this is 30/11/2013.
Yes.
You accept this advertisement, this is
Yes,
correct.
yes, my lord.
Now come to your affidavit.
My lord. Lordship.
This is your appointment or somebody else's appointment?
My appointment.
Your page 38. 38 is yours.
Page 38. No, my lord, no, my lord. That is the another person, my lord, who was subsequent to the appointment, my lord. After the dismissal of the writ petition, my lord, he was appointed, my lord.
This is of 2017. When
Yes,
was the
ma'am.
writ petition appointed?
Writ petition did me on 17/8/2017.
There was a stay order in the writ petition.
No, my lord, no, my lord.
And what is this? Okay. Yes. Yes, madam. Who is appointed where?
It is as per the, what I have, the recent communication that of 19 January lordship, it is stated that the private respondent, he is still working lordship. Other than
No,
the
no,
lordship.
this is somebody else. This is Nazrul Islam, son of Muhib Ali. Is that page 38, not the private respondent?
Mehboob Ali.
Muhib Ali.
Yes.
Muhib Ali. He is different.
And this is, this has been brought on record by the,
Done.
in the affidavit in opposition
Your
to
name?
34 lordship.
Huh?
Ahmed Soikia, my lord.
M.H. Soikia, learned counsel for the petitioner. Also heard Miss Mr. He will say standing counsel, revenue and disaster management. Miss M. Batsaji, learned additional senior government advocate, appearing for the respondents number 2 and 3, and Mr. A.M. Hassan. A.M. Hassan, learned K.M. Hassan, learned counsel for the respondent number 4. The petitioner in the present writ petition has presented a challenge to an order dated 30/11/2013, appointing the respondent number 4 as the Gaon Burah of Toloni Zuria Lot Sam under Mauza Zuria, Rupohi Revenue Circle in the district of Nogam. the projections made in the writ petition, it is seen that in pursuance to an advertisement issued on 8/7/2013, applications were invited for advertisement dated 22/8/2013. Advertisements were invited for filling up of a vacant post of Gaon Burah of Doloni Zuria lot. So, the said post was earlier occupied by one Abdul Mannan, who is the
Grandfather,
Abdul Mannan is the uncle,
grandfather.
grandfather of the petitioner herein. Also, the petitioner, having fulfilled the requisite eligibility criteria, had submitted his application in pursuance to the said advertisement. Also, thereafter, a selection process was instituted, and on conclusion of the said selection process, the respondent authorities vide an order dated 30/11/2013, had proceeded to appoint the respondent number 4 herein. Page 20 is your appointment letter.
Yes, my lord. Annexure D.
As a Gaon Burah of the lot which was earlier held by Abdul Mannan. Also, it is in the order, it is specified that the engagement of the respondent number 4 as Gaon Burah is against the Doloni Zuria lot earlier held by Abdul Mannan, who had since retired from his services. Also, the petitioner being aggrieved by the said engagement effected in respect of the respondent number 4 has instituted the present writ petition. Also, the learned counsel for the petitioner at the outset has submitted that the respondent number 4 herein had not applied in pursuance to the advertisement dated what did you know? Advertisement dated so and so. Advertisement dated 22/8/2013. Also, he submits that the petitioner had also not participated in the selection process. However, the respondent authorities had proceeded to engage the petitioner, the respondent number 4, as the Gaon Burah of the said lot, White Day order dated 30/11/2013. He further projects that he, being a member of a ex-Gaon Burah, family of an ex-Gaon Burah, he was entitled to be granted preferential treatment. However, such preferential treatment has not been extended to the petitioner hearing. Also, however, while making, however, on a query made by this court as to the marks scored by the petitioner in the selection process, the learned counsel for the petitioner has submitted that he has not, the same is not available with him, and no contention in this connection has also been raised in the writ petition. Also, the learned counsel for the petitioner on the said grounds has prayed that the appointment as the engagement as effected in respect of the respondent number 4, White the order dated 30/11/2013, would mandate an interference. Ms. M. Bhattaji, an additional senior government advocate, has submitted that in terms of the instructions furnished to her by the Additional District Commissioner Revenue, Nagaon, it is one Muhammad Nazrul Islam, son of Muhammad Muhubub Muhbub Ali, who is a resident of village Tetelia Bebejia, PS Juria, Mauza Zuria, District Nagaon, who was appointed against the Doloni Zuria lot wide an order dated 16/10/2017, and he is presently working therein. Also, the respondent, and it is not the respondent number 4 who is so working against the said lot. Also, the learned counsel for the respondent number 4 has submitted that he was engaged as a Burah, widely order dated 30/11/2013, and has submitted that in the order, such engagement was against the post of Burah earlier held by one Abdul Mannan, and the lot was identified therein as Doloni Zuria lot. The learned counsel for the respondent number 4 has submitted that after the present writ petition was dismissed for default, wide an order dated 31/8/2017 the respondents, the Deputy Commissioner Nagaon had wide order dated 16/10/2017, appointed one Nazrul Islam as the Burah of Doloni Juria village. They said Nazrul Islam is the person to whom reference is made in the instructions received by Ms. M. Bhattaji, learned additional senior. On a query made as to the order by which the respondent number 4 is presently continuing, who was appointed in the event the appointments affected in engagement affected in his case by the order dated 30/11/2013, and the engagement in respect of Muhammad Nazrul Islam, son of Muhammad Mehboob Islam Ali, effected by order dated 16/10/2017, is found to be for the same lot. He submits that the respondent number 4 is working in a different lot, not the one which was earlier held by Abdul Mannan. Very good. Also, I've heard the learned counsel for the parties and perused the materials available in it. At the outset, this court would consider the claims made by the petitioner in the present writ petition. It is a settled position of law. It is a settled position that in the event a candidate who has participated in a recruitment process for the post of Gaon is aggrieved by engagement made therein of another person, he is required to file an appeal before the appellate, before the prescribed appellate authority. The petitioner in the present petition is found to have not availed the said remedy. However, considering the fact that the present petition is pending since the year 2015 on the records of this court would not at this stage non-suit the petitioner on this said count. Also, the parties are at idiom that the recruitment process for the post of Anganwadi, post of Burah was initiated wide advertisement dated 22/8/2013. The said advertisement, which is in vernacular, being relevant, is extracted hereinwith. Perusal of the said next para of the said advertisement would reveal that a post of Burah of Doloni Zuria lot falling under Rupohi Revenue Circle, Rupohi Moza, earlier held by falling vacant on account of the earlier Burah Abdul Mannan proceeding on retirement, was put up for recruitment and applications were invited from intending candidates. Also, on conclusion of the said selection process, this court finds that void an order dated 30/11/2013, the respondent number 4 herein, that is Nazrul Islam, son of Muhammad Barik, Abdul Barik, resident of Sotian village, was so engaged. In the said order, it is specified that such engagement is against the post earlier held by Abdul Mannan. Also, the pleadings of the respondent number 4 has brought on record another order of engagement issued in respect of Muhammad Nazrul Islam, son of Muhammad Mehboob Ali, for the same very lot, that is Doloni Zuria. Admittedly, the said two orders of engagement issued is found to be against the same lot. There is no clarification in this matter from the respondent authorities in their affidavit. Rather, the said issue has not been dealt with in any manner. Also, the said aspect coming to the notice of this court, coupled with the disclosure in the communication in the instructions furnished by instructions dated 19/1/2026, received by Ms. M. Bhachaji, additional senior government advocate, the following is revealed. B to B, huh? A to A to B to B. A perusal of the said instructions, a perusal of the disclosure made in the said instructions would reveal that one Nazrul Islam, son of late Abdul Barik, resident of village Chaitan, Sotian, Chatin, was engaged as a Burah of Sotian, Nagabandha and Kenduguri under Rupohi Revenue Circle wide and was suspended, and the person is under suspension with effect from a wide was placed under suspension wide order dated 28.4.2023, and departmental proceedings have also been instituted against him. The said person admittedly is not the respondent number 4, because in the present proceedings, no order appointing the respondent number 4 as the Burah of Soitan, Nagabandha, and Kenduguri has been placed on record. The only appointment order placed on record, which is admitted to by the respondent number, by the Learned Counsel for the respondent number 4, is the order of appointment, the order of engagement, appointment jotkushu engagement, order of engagement dated 30/11/2013, which admittedly is against the post of Abdul Mannan. It's against the Duria Doloni lot, which was earlier held by Abdul Mannan. Also, further, the said instructions also reveal that for Duloni Zuria lot, it is one Muhammad Nazrul Islam, son of Muhammad Muhubub Ali, resident of village Tetilia, Bebezia, who has been appointed by order dated 16/10/2017, and he is working. The above facts noticed herein above brings to the forefront two possibilities. One, the respondent number 4 was selected for a particular lot, but was appointed for a different one. Or in the selection process, it is Muhammad Nazrul Islam, son of Muhammad Muhubub Ali, who had submitted his candidature for recruitment, for engagement as the Burah of lot Doloni Zuria. The above situations noticed cannot coexist together. It should be either one of the two. Full stop. Accordingly, a disputed question of fact has come on record, and the same is not permissible to be so resolved by this court basing on the materials available on record. Accordingly, the basing on record. Having drawn the set conclusions, this court would now examine the claim of the petitioner. The petitioner in the present proceeding has only leveled vague allegations without there being any particulars to support his such claims. This court, not being in a position to determine the merit position obtained by the petitioner in the selection process, and also considering the disputed question of fact coming on record with regard to the appointment effected in against the post of Gaon Burah, advertised why the advertisement dated so and so. 13-12 and so. This court is of the considered view that the claims made by the petitioner in the present writ petition would not mandate a consideration on merits, and accordingly, such claims made stand rejected. Also, with regard to the appointments made in respect of Nazrul Islam, son of late Abdul Bari, as the Gaon Burah of Soitan, Nagamandha and Kendu Guri, as well as the appointment effected as in respect of Muhammad Nazrul Islam, son of Muhammad Muhubub Ali, as the Gaon Burah of Lot Doloni Zuria. The Deputy Commissioner Noga shall conduct an inquiry into the matter after affording an opportunity to both Nazrul Islam, son of late Abdul Barik, who is projected to be engaged as Gaon Burah of Soitan, Nagamandho and Kenduguri lot under Rupohi Revenue Circle, and Muhammad Nazrul Islam, son of Muhammad Muhubub Ali, who is projected to be engaged as Gaon Burah of Doloni Zuria lot, and thereafter pass appropriate orders with regard to the engagement, with regard to the manner of engagement. The Deputy Commissioner during the inquiry shall examine the manner in which the respondent number 4 in the present proceedings was appointed, as well as the manner in which Muhammad Nazrul Islam, son of Muhammad Muhubub Ali, was so engaged. Manner of engagement of so and so, as well as the manner of engagement, procedure followed for engagement of Muhammad Nazrul Islam, son of Muhammad Muhubub Ali. Also, on inquiry being carried out in the manner as directed herein above, the Deputy Commissioner shall pass a speaking order with regard to the findings arrived at, with regard to the determination made by him with regard the determination made by him on the issue noticed by this court herein above, for which the inquiry is being directed. Also, the Deputy Commissioner, on conclusion of the said inquiry, shall pass a speaking order and communicate the same to both the Nazrul Islams noticed herein above, along with the decision with regard to their continuation as Gaon Burahs against the posts to which they were so engaged. The above exercise shall be initiated and concluded by the Deputy Commissioner Gaon within a period of 6 months from the date of a receipt of a copy of this court order from Ms. M. Bhachaji, learned additional senior government advocate. Ms. M. Bhachaji is requested to download a copy of the present order and forward the same with due acknowledgement to the Deputy Commissioner, Nagaon for compliance. Also, with the above observations and directions, the present petition stands.
My lord, may be allowed a liberty to approach before the concerned authority, my lord.
If the appointments are gone, then the post will come, you get it.
After the inquiry.
After
After
that,
that.
you get it.
My lord.
And if that is correct, they'll connect. It might be like that Kisamat has many lots.
Yes.
He is in a part and the other one is in a part.
Other part, yes.
But how could that could be done from one advertisement? There has to be two advertisements. I'll put that also in, don't worry.
My lord, admittedly, there are several parts and he has been appointed in place of my grandfather place, my lord.
Okay.
And that second Nazrul Islam is from by another appointment, my lord.
It's the other way around.
Other way.
But
It's
these
other way.
advertisements are also not, these
Okay,
are
fine.
outdated now, Lord.
Fine, fine.
Deeply applied.
Deeply applied.
I'm applying for number
My level. Only my level.
I'm applying for number 1 into
Oh, respond now.
as the clerk.
Push it to like, push it to my telling also.
Now let's
Yes,
next case. One instruction we received. Lordship.
rectified proposal you have
Lordship,
got.
and the money has been
Done.
deposited in the treasury, Lordship.
Okay. None appears for the petition on call. Mr. S. Dr. Learned Standing Counsel, Revenue and Disaster Management submits that on a rectified proposal with regard to the authorization of ex-gratia amount of rupees 2 lakhs to the next of kin of late Papu Burah, who had died on account of an accident in a public place being received, from the district magistrate, Dima Hasau, the Revenue and Disaster Management Department has released budget allotment for an amount of rupees 2 lakhs to the concerned BDU on 18/3/2026. The said amount is to be now is for the payment of ex-gratia to the next of kin of late Papu Burah. The petitioner herein, the petitioner herein is projected as the person in whose favor the said authorization has been made. Mr. Dr. submits that the said amount has already been received by the treasury officer, by the jurisdictional treasury officer, and the amount would be credited in the account of the petitioner herein, if not already credited within a period of 15 days from today. So, in view of the said development taking place in the matter and the petitioner being authorized the ex-gratia amount claimed by her in the present petition, this court finds that there is no further live issue to be considered, and accordingly, the present petition stands closed. A copy of the instructions furnished by Mr. S. Dr. is kept on record and marked as X for the purpose of identification.
Obliged.
My lord, before I start, my lord,
I must acknowledge, my lord, that fairly, my lord, the law is, my lord, otherwise, my lord. So far, my issue is concerned, my lord.
Matter is otherwise.
Issue is
You
otherwise,
Show me the otherwise thing.
meaning thereby, my lord, if I may say so, my lord, the law is not in much favorable to me, my lord. So I was thinking, my lord, if I could, my lord, considering the genuineness of the petitioner, my lord, genuine
All
grievance,
things are genuine.
genuine grievance of the petitioner, my lord.
Every grievance is genuine.
Yes,
But you got to factor in the time when you have made also.
exactly, my lord.
And the manner in which it was.
Therefore, my lord, I was just thinking, my lord, to explore some other,
I've explored in.
so that I can
You make your submissions.
convey, my lord,
You
pursue
make
your
your
lordship, my lord.
submissions. Make
No
your
doubt, my lord, lordship is may have more, maybe more much compassion, my lord. I have no doubt about it, my lord.
You make that compassion light here.
Yes.
I'm with you.
So, my lord,
I'll tell you what is against you. What I'm
Yes.
thinking against you. One, you make an application. That application gets rejected for X, Y, Z reason.
yes,
You stop. You do nothing.
yes,
Your son comes up. Now you stop. Now you send your son with that application. There is a need. That's why you did it. Now the application of the son not being considered matter comes up before this court. This court rejects that. And there is an observation in para 9 that see, it is the mother who should have challenged it.
exactly.
There is
lordship.
a delay,
Exactly, lordship.
right? You file a review. You worsen the situation. You file a review application. You have worsened the situation because this court rejected that review application.
My lord,
That is-
if I may,
That is this. That is the end of the matter.
Yes, my lord, if I may, otherwise, my lord says so. My lord, issue is there was a 72-day delay. 72 days delay in submitting my application. That is the objection. Now, so far, review part is concerned, my lord.
Mr. Counsel, it's not the reason now that is, it's the delay.
Yes, now, so far, my lord, the review part is concerned, my lord. Since lordship, the coordinate bench of this court, my lord, with your respect, came to findings that application was submitted on so and so date, and by the time you file a writ petition by son, that petition has been dismissed by the DLC, rejected. Therefore, the court was of the opinion that it was the matter who should have challenged before, I would have come before this court, and seeing that there was a finding that application was submitted on time. Therefore, my lord, we thought it, my lord.
Finished. It's
Now the petitioner
come
thought
to
it,
that.
my lord.
Come to that straight away.
Yes,
Come to that straight away.
kindly, my lord.
Hmm.
Kindly see, my lord, page
Hmm.
101, second
Hmm.
paragraph, my
Hmm.
lord.
Hmm.
Mr. So-and-so,
Hmm.
my lord, if I may.
Yes, yes, yes.
Mr. So-and-so, learned counsel for the respondent submit that on the death of late so-and-so, the wife of the deceased applied for compassionate
No,
agreement
come
on
to para 9.
so-and-so. Yes. Lordship may kindly, yes, para 9, second paragraph, my lord, starting from my lord.
In the present case.
In the present case, it is not in dispute by the parties that on the death of so-and-so, wife of had applied for compassionate employment within the time limit on 5/9/2013, and the same has been rejected by the DLC on so-and-so. And that is the petitioner has not specified in his pleading as to who has submitted the application for compassionate employment on so-and-so. And as there has been no denial of the averment made by the respondent, the wife of so-and-so has submitted an application for compassionate employment on 5/9/2013. It is clear that the application was submitted by wife of so-and-so on 5/9/2013.
Mr. Counsel, this application was rejected in 2014.
That is what I'm
Once
telling you.
you did not know about it.
Yes.
But your need for compassionate appointment was there. You were finding it difficult to sustain yourself.
Yes.
Why did you wait till for 5 further years or 6 further years
Yes, my lord.
for your son to come up before this
No.
court? Why did you not come up? One. Now this position has been further worsened for you in the review.
Now, therefore, we thought it that with caution, my lord, we file a review, saying that since the observation has been laid out, if I may challenge, my lord, and now the present petitioner, there may be some obstacle. Therefore, my lord, because of applying constructive res judicata or res judicata,
It is already
whatever may be,
constructive
my
res
lord.
judicata.
On
This writ petition is hit by constructive res judicata.
yes. Therefore, my lord,
And
whatever may
dismiss it
be,
on that.
therefore we file a review. Lord, now lordship's court has said that no, liberty is always with you. You file because you have to challenge. No, that was the lordship. That was
We
the
say
purpose,
100
my lord.
things.
So
But what
review
is-
review
what
is
is-
not maintainable. I have not arrived any findings against you. Therefore, my lord,
On considering so and so does not find a case for review has been made out. Inasmuch as there is no dispute with regard to the correctness of the observations
yes.
reflect, finished.
Therefore, that observation is otherwise, my lord,
Anything
in
more?
my favor, my lord.
Anything
That
more?
observation, my lord, with due respect, in my favor, my lord.
But that is,
Therefore,
that is.
the son has then.
Devabrata Tiwari.
Yes, that's why para 7-4. That's why I may, if I may distinguish, my lord, two aspects, my lord. Para
No, we are
7-1-4 and 5.
permitting you.
Two
Tell me
aspects, my
about
lord.
the delay only.
Two
Where
aspects,
is your
my lord.
justification for delay?
Delay, my lord, my son bona fidely filed petition, my lord. Therefore, two parallel, I cannot proceed ahead, my lord.
Only one son.
Only one son.
If there were another two sons, they would have also have come up in serial before.
No, my lord, that is maybe.
Compassionate appointment is not something which.
Therefore, my lord,
Mr. Murray,
yes, my lord.
compassionate appointment is not something which this court will consider after 15 years.
Absolutely, my lord, what?
Absolutely, you agree to that proposition.
But my lord,
That is the end of the matter.
I may supplement something, my lord, if lordship had me.
But if you waste further time,
only
I'll
5
impose
minutes,
in
my lord.
5 minutes. Okay, I give you 5.
Therefore, my lord, when my son attained majority, my lord, my lord, the son had applied. Now, when the writ petition has been came up before this court, my lord, I came to know that my petition has been rejected by the DLC. Therefore, my lord, kindly see my application, my lord. What has been in the application, my lord? There was a notification, my lord, 2012, that whatever decision has been taken, it is the authority to communicate. That is then a notification I have enclosed, my lord. Now, my lord, the government authority also, my lord, there is a memorandum in 2015, my lord. They may have considered as a one-time measure, my lord, in any other department also, my lord. Nothing has been done, my lord. Therefore, my lord, by this writ petition, my lord, and my lord, in the year 2019, the respondent authority has communicated me my case for rejection, my lord. Only in the year 2019, I have enclosed, my lord, in my writ petition also the communication letter, my lord, annexure 13, my lord. Therefore, my lord, only thing what I'm concerning is, my lord, because of lordship has indicated me that judgment, my lord, if I may distinguish, my lord, that two aspects were in para 7.5, that is clear, my lord. That is, my lord, in that case, my lord, the court was of the view that, my lord, the claimant might have, my lord, better source of income or
I'll tell you what
better employment, my lord.
What the court has said. The delay on the part of the applicant.
That is correct,
Or
my
the
lord.
delay caused because of the inaction.
Whatever may be the
whatever it is.
circumstances, either on the part of the department or on my part. But my lord, that condition, my lord, that condition may subject to, my lord, that better,
Appeal.
my lord, better opportunity has been.
Appeal. Next round is appeal. Keep your
My lord,
energy for your appeal.
lordship, I'm obliged, my lord.
Keep your energy for your appeal. Next appeal. Dismissed.
Obliged, my lord. At least, my lord, otherwise, my lord, let them at least pursue me, at least opportunity, my lord.
Only one application is permissible. You made 2 applications.
No, my
You
lord,
made 2 applications.
there may not be bar.
But there is a bar. Who said there is no bar?
There
One
may not be
application
absolute bar.
has been rejected. If it was not considered, fine, but rejected.
The only thing is necessity, my lord, only this
Necessity, that postway has gone to some man in the village.
How that has been going, my lord?
That is,
They
you're
now
getting a
came up,
pension.
my lord, you have
You're
not
getting a
submitted an
pension.
application.
You're getting a pension. You are getting a
is
pension.
Very small amount.
Be that as if you're getting a pension.
Yes, my
There
lord.
are lakhs and lakhs of people in the villages who have not even got a naya paisa. So,
Had it been
Mr.
the case,
Murray,
my lord, if they
don't
have,
make those submissions before.
had it been the case, my lord, if they
Delay
had considered, my
is
lord,
not a ground.
that,
Delay,
that is of course, my lord.
when there is a delay,
But
And
delay
after
must
15 years, the need for compassionate appointment is not.
But delay must be conjointly repeated. So enter, my lord. Another
You go up on appeal. I'll give you the order. You go up on appeal to reserve this energy for the appeal. Yes, anything fine?
I'm obliged, my lord.
What would be? FIR, sir. Itu tu judgment of constitution, order constitution. Photo. You have got the instructions, Mr. Abhay. Yes.
Lordship, in fact, Lordship, after getting approval from the finance department, in the month of February, Lordship, 2011, one list of 72 was there. Subsequently, Lordship, 13 names were replaced in the month of September, same year, Lordship.
Okay.
Finance,
There are two lists.
there were two lists of 72. So in the second list, Lordship, their names were there, excluding 4, Lordship. They were not there in the 120 list also, to be honest, Lordship. They were not there. But for what reason, Lordship, their names were included, Lordship? That is no
So
explanation.
with regard to that 4 persons, we will direct you to conduct an inquiry and then take necessary steps.
Lordship, file is totally, I mean, silent to that aspect, Lordship, how their name came.
How their name came.
But as on date, Lordship, out of that 72, 47 are working, Lordship.
And that includes those 53 too.
They are not there.
They are not there.
These 4 are not there.
So make that statement. Let it be, call Mr. Bhuya. Make that statement at 2. We'll pass the order.
Lordship.
We have closed the IA, and with regard to the main writ petition, we have dismissed it. Get the order by Monday or Tuesday.
Highly obliged, Your Lordship.
May I please, Lordship, I relate upon one judgment. It's forward case. Because they were not engaged in any project or scheme. They were engaged against the vacancy in a department. And if my lord.
They were not engaged against any post.
No, very specifically, I have narrated paragraph 5, and that file also revealed the fact against the vacancy.
No.
When 5 persons
No.
regularized.
There is no vacancy.
Then against that vacant post, they were engaged.
There is no vacant post, Mr.
My lord, the paragraph 5, I have very clearly.
You have said they were
Specifically
engaged on
mentioned.
as fixed pay. They were engaged as fixed pay.
That is that, Lordship.
How can it be as then how can you say that it is against a
I
post?
have also engaged, I enclose, my lord, salary statement regarding the bank transfer, their salary disbursed. And the bank statement saying that 15 months they have continuing receive the salary.
For 15 months.
15 months continuously. And this judgment saying, my lord, paragraph 1 saying, my lord, if paragraph 1 saying, my lord, page 32, I have flag mark, saying that in daily rated casual labor versus Union of India, the Supreme Court by its judgment that so and so directed the department to formulate a scheme under which all casual labor who had rendered more than 1 year continuous service and could be absorbed. So
Uma Devi?
Lordship.
Uma Devi, what do you say?
That is a master role employee, my lord.
Master role, casual, everything will come in.
here-
What do you say
here-
about
here-
Uma Devi?
but
It's a
some-
constitution bench.
But someone also
Mr. Bhuya, it's a constitution bench judgment.
my lordship, correct, my lord. But someone also rendered more than 10 years. So her lordship.
10 years as of, when was your first date of engagement? That you can't tell me.
That is, they were engaged, my lord, petition number 5, page.
Where is your engagement order?
Actually, my lord,
They were engaged from 2004.
somewhere 2004,
And
somewhere
then
2005.
earliest one is when?
Yes, lordship. Somewhere 2008,
Ah.
I have enclosed, my lord. And this, my lord, if someone already availed the benefit, there
You
is.
tell me, Mr. Bhuya, when was the first engagement amongst the petitioners made? Earliest engagement?
Yes. My lord,
Okay,
I have.
you find that out, we'll hear you.
Lordship, that is page, my lord, petition number 2, so about 2 is concerned. He was engaged on page, my lord, 30. Page 30, 30.
Hmm.
on 19/10/2004.
1910?
2004.
Oh.
Page 30.
So they had not completed even 2 years when the Uma Devi's judgment had come in.
The 2004, my
So
lord.
10 years thing.
Continuously.
Uma
my
Devi,
lord,
it will not be
the
completed.
writ petition filed in the month of March
Yes,
2015.
let's see on facts what is. There. Yes,
2015.
Mr.
Out of the 4 petitioners, nobody has annexed any appointment letter, Lord.
Forget it.
They're simply saying that since
Where do you give appointment letters to muster roll workers casual? You don't give.
We
So
don't.
why raise that argument?
yes,
Then tell me about those 4 people.
yes. Lordship,
53 to 58.
Lordship has already seen the record. In the page 61 of the writ petition, Lordship will find one
That is there.
select list of 72.
Select list,
Not
select
select
list.
list. Lordship, in fact, Finance Department gave the numbers. Finance,
No, you tell me. This list is the same list that is there.
yes.
Then what do you know about this?
Lordship, initially this list was prepared after approval by the Finance Department on 6/2/2011.
Oh.
Page 63, Lordship will get the
Hmm.
next Lordship in the month of September, 21st September 2011. 13 of this list was replaced by another 13. I'm placing that list, Lordship.
So this is the list. No, this list at page 64 is what is there in the input
Page
doc.
64 from the list of 72 prepared in the year 2011 September. So there Lordship will get the names of the other persons. Lordship, however, 4 of the persons, Lordship, were not there.
Can you give me a Xerox of this?
Yes, sir.
And the relevant.
Lordship, those ink marks have been, it was my me, Lordship.
No,
Fix the page.
The page number.
we have seen it. You give me a Xerox of this and both the cases, the relevant office notes, the processing. Give it to me, give it to her. I don't want to retain this, important records.
Yes, that is one, Lordship. Then if Lordship comes to my affidavit, Lordship, by Finance Department, Lordship. Finance Department by one Ratul Chandra Kakoti. Respond number 3, Lordship. If Lordship comes to paragraph 5. Just one paragraph affidavit, Lordship. Paragraph, the writ petition, the deponent begs to state that it is a fact that Finance Department, it was only for 1 year, Lordship. Lordship will kindly note that.
Can you give me the relevant copies? And from 15, they are not working.
Yes, Lordship. That is the final, Lordship. From their statement also, Lordship, it is available, the bank statements, wherein it has been shown that since January 2015, they are not receiving any salary. And our statement is that they are not working even.
And they have drawn their salaries from June 2013 to December 2014.
That list has been given.
October 2013.
October 2013. So from 2004 to, how were you working?
Thereafter, my lord, has been stopped.
I know, but before that, how were you?
Therefore, my lord, we approach.
No, before that, how were you working?
Yes.
Before 13.
That is, I have narrated file number 48, 2012. That has maintained.
No.
Salary was on cash and it was maintained on acquaintance. I have narrated, my lord.
Where are your statements here to that? That you have been paid in cash, you have been paid in from the date of your appointment? Can you give it today?
Give during the course of the day.
Paragraph, my lord.
Okay. Heard Mr. K. Bhuiyan, Learned Counsel for the petition. I also heard Mr. P. Nayak, Learned Additional Advocate General, along with Mr. A. Fukan, Learned Standing Counsel, SAD Department, as Secretariat Administration Department. Hearing concluded, registry to list this matter again. Budbare parine list asen. No, delivery of order karne. Birihospatibar. বন্ধ আছে 20 তারিখ 20 খোলা দিনা আছে নেকি ডেট টু দি দিবা তুমি
20 খোলা আছে
you give it on Monday because it's all full Monday he still give a date.
Just one more thing, Lordship. These additional persons are not in the writ petition. They are not party. one, and against them, Lordship, petitioner has no grievance.
Don't take that plea
Oh.
as a state
Just
don't
he's
take that
repeatedly,
and give me a small note of what you found
Finance.
along with these 4 people. Give me a small note. Consult with Mr. Thing and give it to me.
Lordship.
We'll not accept that plea. That they are not a party. If
Lordship,
there is a illegality found
Lordship.
with regard to the discrimination found with regard to the respondents, we will come in. To
Lordship,
that extent, we will come in. But you give me those.
Lordship, Lord, it will be given. Lord. Monday goes on.
Mistaken, 20th, 20.
Obliged,
20.
Lordship, obliged.
Obliged, Lordship.
Yes. Nothing more. We'll proceed.
My lord. There is a huge difference of age between the primary school record and the board certificate.
That you go before that we are not.
And
Matriculation is a.
also from private.
Council, the matriculation is the one which we have.
Yeah, this is
But Mr.
all
You,
Oscar.
you are UN Chetri.
All Oscar.
You owe Chetri.
All Oscar.
Oh, you are all Oscar. Sorry. All Oscar, Learned Counsel for the petitioner. Also heard Mr. D.B. Burah, Learned Standing Counsel. Learned Standing Counsel.
Health Department.
Health and Family Welfare Department, appearing for all the respondents. The petitioner in the.
Not for
present-
the respondent. There is one private respondent.
Oh, for the respondent number 1 and 2. And Mr. There was a counsel for the.
Yeah,
respondent-
Desi Gogoi, he appeared, my lord. on
Mr.
that.
And also Mr. C. Gogoi, learned counsel appearing for the respondent number 4.
3.
3, sorry. The present writ petition has been instituted. Mr. Loskor, you can have your seat. Has been instituted by the petitioner hearing. The present writ petition has been instituted by the petitioner. Essentially, the selection and appointment of the respondent number 3 as against the post of dresser, DRESSER, in pursuance to an advertisement dated 6/9/2020. Also, the petitioner in the present writ petition has projected that the Director of Health Services Assam, that is the respondent number 2 hearing, had issued an advertisement dated 6/9/2020 amongst other posts, inviting applications from intending candidates for filling up of grade 3 posts of technical, grade 3 posts bracketed technical, including the post of dresser. 15 posts of dresser were put up for recruitment while they said advertisement. Also, it is projected that in terms of the said advertisement, in terms of the eligibility criteria spelled out in the said advertisement, the intending candidate is required to have a HSSLC qualification, HSSLC or equivalent qualification with experience in dressing bracketed at least for 3 years. It is further projected in the writ petition that the petitioner, having been serving under the National Health Mission authorities, with effect from 25/2/2009 as a contractual worker, as an office peon on contractual basis, the petitioner had, by projecting the said position, submitted his application. It is found that along with the petitioner, the respondent number 3 had also submitted his application. The application submitted by the petitioner and the respondent number 6 and others on being scrutinized, having been found to have satisfied the eligibility criteria set out in the advertisement, they were required to appear in a written examination. Also, On a conclusion of the written examination, it was found that both the petitioner, the respondent number 3 and others who had scored marks above the cutoff marks prescribed. On conclusion of after the written examination was so held, by the notice dated 26/11/2021, the Director of Health Services Assam published a panel list of candidates found eligible for appearing in the skill test in the next round of selection, that is in the skill test. The name of the petitioner as well as the respondent number 3 finds place in the said panel list so published by the notice dated 26/11/2021. It is further projected by the petitioner that he had appeared in the skill test, and on conclusion of the selection process, the Director of Health Services Assam, by notice dated 11/5/2022, published a select list against 15 posts of dressers as put up for advertisement by the advertisement dated 6/9/2020. In the said select list, the name of the petitioner did not figure. However, the name of the respondent number 3 figured therein. In terms of his selection, the respondent number 3, along with other selected candidates, were appointed as a dresser by an order dated 14/5/2022. Subpara. Being aggrieved, the petitioner has instituted the present writ petition. Mr. O. Lascott, learned counsel for the petitioner, by reiterating the facts as noticed herein above, has submitted that in the said advertisement dated 6/9/2020, it was stipulated that the intending candidate should not be less than 18 years and not more than 40 years as on 1/1/2020, with upper age limit relaxation provided for OBC, reserve community candidates, category candidates. He submits that the petitioner herein, that the respondent number 3 herein, on the date he was so engaged for, he had submitted his application and crossed the upper age limit as prescribed in the advertisement, and the age of the petitioner was even beyond the age for which relaxation was permissible for candidates belonging to the reserve community category. Also, he submits that the petitioner, that the respondent number 3, having been brought into the purview of the select list, although he did not have the eligibility with regard to the age criteria as stipulated in the advertisement, the selection of the respondent number 3 being of a candidate not fulfilling the eligibility criteria as mandated in the advertisement would mandate an interference. Mr. Loscott has further submitted that the advertisement having mandated that along with the intending candidate, along with possessing the qualification of HSSLC pass, also is to have experience of minimum at least 3 years in the field of dressing, in dressing, he submits that the respondent number 3 does not possess the set qualification with regard to experience, and accordingly, his case was not permissible to be so considered in the selection process held in pursuance to the said advertisement dated 6/9/2020. Accordingly, he submits that on account of the above noted 2 grounds, the selection and appointment of the respondent number 6 would mandate an interference from this court. That much only. Mr. D.P. Burah, learned counsel for the petitioner, has submitted that the respondent number 3 had participated in the selection process on the basis of a selection process and for the purpose of establishing his age, had relied upon a matriculation certificate issued by the Board of Secondary Education, Assam. He submits that the petitioner's age in the said certificate, the petitioner's date of birth in the said certificate was recorded as 1/8/1988. Accordingly, he submits that on the last date of submission of the application, in terms of the advertisement dated, submits that as on 1/1/2020, the petitioner had not, the respondent number 3 had not crossed the upper age limit as mandated in the matter, as stipulated in the matter. So, accordingly, he submits that the petitioner had participated in the selection process by fulfilling the eligibility criteria with fulfilling the age criteria as set out in the advertisement dated so and so. With regard to the submission raised, the contention of the learned counsel for the petitioner that the petitioner that the respondent number 3 did not have an experience of at least 3 years in dressing. Mr. Burah has submitted that the application as submitted by the petitioner was submits that a certificate was enclosed to the application submitted by the petitioner online, and on a perusal of the said certificate, it is seen that the petitioner had the experience of working as a dresser at Northeast Nursing Home with effect from August 2010. He submits that the said certificate had established that the petitioner had also, that the respondent number 3 had also fulfilled the eligibility criteria with regard to experience as set out in the advertisement dated so and so. Accordingly, Mr. Burah has further submitted that in the selection process, while the petitioner had secured, what are the marks secured?
My lord, the petitioner secured 45 marks in written test and 21 marks in skill test.
45?
Written test and 21 in skill test.
While the petitioner secured 66 marks in the 2 segments of the selection process, that is the written examination as well as the skill test and the skill test, the respondent number 3 had secured
86 in written test and 20 in skill test.
Had secured 86 marks, had secured 86 and 20. Had secured 106 marks in the 2 segments of the selection process. Mr. Burah submits that the breakup of the marks secured by the petitioner and the respondent number 6 is as follows. The petitioner in the written examination had secured 45 marks and had secured 21 marks in the skill test, while the respondent number 3 in the written examination had secured 86 marks and had secured 20 marks in the skill test. Mr. Burah has further submitted that the marks as given to the candidates, even to the also, in the above premises, Mr. Burah submits that there is no, that the grounds urged by the learned counsel for the petitioner for assailing the selection and appointment of the respondent number 3 would not mandate an acceptance, and the writ petition would be mandated to be dismissed. I've heard the learned counsel for the petitioner. I learned counsel for the parties and peruse the materials available on record. The facts noticed herein above are not in dispute and accordingly are not reiterated. The petitioner had assailed the selection of the respondent number 3 primarily on the following 2 grounds. A, that the petitioner, that the respondent number 3 on the date of submission of his application was overaged and accordingly had not met the age criteria set out in the advertisement dated 6/9/20. Also, and B, the petitioner, the respondent number 3 did not have the criteria set out in the advertisement pertaining to experience. That is, he did not have 3 years experience in dressing. Also, with regard to the first ground urged by the learned counsel for the petitioner, this court finds from the records of the matter, finds from the materials brought on record in the present writ petition by the respondent number 3 that the respondent number 3 had appeared in his high school leaving certificate examination in the year 2015 and in the certificate so issued to him by the Board of Secondary Education Assam, his date of birth was recorded as 1/8/1988. The prescription with regard to the age criteria is to be achieved by the intending candidate in terms of the advertisement dated 6/9/2020 as of 1/1/2020. The petitioner, considering the age of the respondent number 3 as reflected in his HSLC certificate, this court finds that the petitioner was within the age limit prescribed for applying in pursuance to the advertisement dated so and so for the post of dresser. The learned counsel for the petitioner had drawn support with regard to the age of the petitioner by relying on the age of the petition of the respondent number 3, petitioner ko respondent number 3. Respondent number 3 as recorded in his school records. The age of the respondent number 3 as recorded in his school records would not be of any material consideration inasmuch as it is a settled position of law that it is the age, it is the date of birth of a candidate as recorded in his HSLC certificate that would be given primacy for the purpose of drawing satisfaction with regard to the age of the petitioner of the candidate on the date he had submitted his application. The data from the date of birth of the respondent number 3 as recorded in his HSLC certificate, this court is of the considered view that the petitioner, that the respondent number 3 was within the age limit prescribed in the advertisement dated so and so, and accordingly on the set count, the selection and appointment of the respondent number 3 would not mandate an interference. With regard to the second ground urged by the learned counsel for the petitioner, that is that the respondent number 3 did not satisfy the criteria with regard to experience as set out in the advertisement dated so and so, this court finds this court had required Mr. D.P. Burah, learned counsel, appearing for the state respondents to place on record the application form, the online application form along with the documents uploaded along with the documents appended to it pertaining to the experience criteria possessed by the respondent number 3. Mr. Burah had produced the online application form of the respondent number 3 along with an experience certificate appended thereto. Also, on a perusal, this court on a perusal of the certificate produced by appended to the application submitted by the respondent number 3, finds that the respondent number 3 had the experience of working as a dresser at Northeast Nursing Home with effect from August 2010 till the date of issuance of the said certificate, which was on 21/12/2017. This court finds that from the said certificate, the respondent number 3 had more than 3 years of experience of working as a dresser. It is to be noted that in the advertisement dated so and so, the experience criteria was not mandated to be so possessed, so acquired by a candidate concerned from a particular nature of institution, that is, from a government institution and or a hospital and or from a particular nature of from a particular institution. It was not further stipulated that such experience would also be mandated to be so possessed, so acquired while working in a government institution and or a government aided institution. Also, accordingly, the experience that has been garnered by the respondent number 3 while as a dresser while working in Northeast Nursing Home would have to be taken into consideration for the purpose of determining as to whether he satisfied the experience criteria as stipulated in the advertisement dated so and so. Also, accordingly, this court having found that the respondent number 3 had fulfilled the experience criteria mandated in the advertisement dated so and so, this court would not proceed further. This court holds that on the said ground also, the selection and appointment of the respondent number 3 would not mandate an interference. Having drawn the said conclusions, this court would now consider the submission made by Mr. O. Laskar, learned counsel for the petitioner, that the petitioner, having been working in the NHM, having worked under the NHM authorities, he was entitled to be given a weightage of 2 marks per year of service, completed year of service under NHM, subject to a maximum of 20 marks in terms of clause 7 of the advertisement dated so and so. Clause 7 of the said advertisement dated so and so stipulates that contractual employees working under NHM as nurses, paramedics, etc. be given a weightage of 2 marks per year of completed service under NHM, subject to a maximum of 20 marks so that they can be given suitable and justified preference. The clause 7, the weightage as contemplated under clause 7 in the considered view of this court is in relation to the experience gathered by the candidate with regard to the works of the post which has been put up for recruitment and he intends to he intends to apply against. They said experience cannot be construed because the nature of duties mandated for the post against which the intending candidate wishes to apply in pursuance to the advertisement in question. In the present case, it is the projection of the petitioner that he has been working with the NHM authorities as an office peon on contractual basis. It is not the contention of the petitioner that he is discharging duties under the he is performing performing works of a dresser under the NHM authorities during the period of his such engagement with them. The nature of duties discharged by the petitioner under the NHM authorities having got no relationship with the nature of duties to be discharged by a person appointed to the post of dresser, the non-award of marks of weightage to the petitioner in terms of clause 7 of the advertisement dated so and so in the considered view of this court is not erroneous and the respondent authorities are not called upon to be directed to award, to authorize, to assign the marks, weightage marks as contemplated under clause 7 of the advertisement dated so and so to the petitioner hearing. Accordingly, the contentions raised by the petitioner in this connection stands rejected. Also, in view of the above discussion, this court having not found any good ground for setting aside, for interfering with the selection and appointment of the respondent number 3, this court is of the considered view that the claims made by the petitioner in the present writ petition would not mandate acceptance. Accordingly, the present writ petition is held to be devoid of any merit and the same consequently stands dismissed. A copy of the application form furnished by Mr. D.P. Burah, Learned, Standing Counsel, Health and Family Welfare, copy of the online application form of the respondent along with the certificate appended thereto, furnished by so and so, is kept on record and marked as X. Sorry, Mr. Loscott.
Obliged.
Yeah. Where is your terms and condition of your agreement?
Recruitment. Okay, so let's have 3, my lord.
Annexure 4, page
Page?
18, page 18.
Page 9, termination of contract.
It was last extended till?
This is the only contract that was there. After that, there was no contract.
How do you keep on engaging a accredited engineer beyond the period of contract?
I was told that although the authorities wanted to get into a contract with the petitioners, but the group of petitioners along with the petitioners didn't want to sign a contract.
So they don't have a contract after this.
No, so they were continuing after that.
Order of release is on
That is
page 30.
30, my lord. The order of implement of this, that is 30,
23.
my lord.
Yes, Mr. Chaudhary.
My lord, I have some regarding this, my lord. Only one thing, my lord, to be considered. My lord, they cannot deny the employee relationship with me, my lord. Because they have taken, at the same time, they cannot take the appropriate and reprobate relationship, my lord. They engage, they taken works, my lord, they have from me, and now they will say that you are not in our employee. They have given salary. No, it is their duty.
Supreme Court is very clear on
yes,
this
my
point.
lord. It was their duty to terminate on the right time. They did not terminate it. They paid me salary. They take my works, and now they said you are not the employee. It is settled principle, my lord. I have in the, my lord, in the limited 4 point here to be considered, my lord. This is my submission. First of all, my lord, no regular inquiry held. Number one.
Now, show me the requirement for a regular inquiry in the terms and conditions of your engagement.
Even
In
if
fact,
an ad hoc employee, if he's terminated, my
show
lord,
me the law that it is automatically, principles of natural justice will come in.
yes, my lord.
That is why a notice has been given.
It does
Where
not
is
have to, my lord.
311 coming in?
Thereafter, my lord,
Where is 311 coming in? Show me that.
my lord,
Notice, natural justice, I understand.
yes,
They'll give you a notice, you reply, then they will apply their mind and then pass an order.
yes, my lord.
I understand to that effect. But where is the requirement of 311? That there has to be an inquiry, there has to be an inquiry report, copy given, then you take the matter forward. Where is that requirement?
My lord, even ad hoc employee, my lord, after employee, there, I am employed there, my lord, I am getting salary, I am working there, my lord. At the time of termination, at least minimum this is as per Article 311, minimum this is.
Show me that Article 311 is attracted to your case. Just show me a decision.
My lord, that is, I have submitted an order copy of this honorable court, my lord, covered case. So page, para 23, my lord, this 3 or 4 para, I completely covered my case, my lord.
Okay, let us show me. Show me. Which case?
That is Syed Masood Majumdar, my lord.
Syed Masood Majumdar. Where it is said?
Para. May I read, my lord? Para 23. On careful examination of the different orders of the termination of service imputed in the present batch of the distribution, I find that those orders had not only dealt with issues which were strictly not the subject matter of the show cause notices served upon the employees, but none of the orders even remotely indicate as to in what manner the show cause reply furnished by these respective employees had been dealt with by the concerned authority before issuing the order of termination from service. Not only that, it also appears that the order of termination from service was also substantially based on inquiry conducted behind the back of the respective petitioner, and without even furnishing them with a copy of the inquiry report, it is not clear from the materials available on record as to what manner and to what extent the findings of the inquiry conducted behind the back of the petitioners had weighed with the authority while issuing the respective orders of termination. This court is thereof the considered opinion that apart from failing to give the petitioners a reasonable opportunity to defend their interests, the respondents have also failed to establish the allegation of negligence misconduct brought against the individual petitioner based on cogent materials. Therefore, kindly see 25, my lord. From the materials on record, it appears that some opportunity was given to the petitioner to explain their stand. However, as noted above, although there are serious allegations of misconduct brought against them, including allegations of the financial irregularities, yet no proper inquiry was conducted to establish such charge. Not only that, even the explanation submitted by the petitioners have not been properly dealt with. Moreover, it has also been noticed that the impugned order of termination of survey had addressed issues which are not a part of the show cause notice, thus denying the employee of an opportunity to submit the response in that regard. An order for termination on the allegation of misconduct cannot be issued based on circumstances which did not form a part of show cause notice. Under such circumstances, merely because of show cause notice was served, can it be said that the principle of natural justice has been complied with in these cases? In other words, did the petitioners
These are cases on the facts of the matter. 1. 2. This court, while coordinate bench while passing these orders, had not noticed the Supreme Court case in Gripco.
Yes, my lord. My lord, para 31, my lord.
Oh, it has been noted.
Coming to the fact of the case, it is no doubt correct that before issuing the orders of termination and show cause notice was served upon each of the petitioners, thus giving them an opportunity to submit their reply. It is also apparent that after the show cause replies were received, the orders of termination had been issued. However, none of the orders of termination impugned in the present batch of petitioners can remotely indicate as to what manner the replies submitted by the individual petitioners have been dealt with before arriving at the conclusion that they were negligent in the discharging their duties. Thereafter come under 33 page, that is regarding REITCO also, my lord.
That REITCO is noted, but it has not been, just been noted. There was no finding recorded with regard to. Now, show me the show cause.
show cause. Engagement. Contractual. Suppose page 24, my lord. Along with the report submitted.
There was a PIL in this matter here.
Yes, my lord. But regarding my case, my lord, no specific
fine.
allegation.
Then let us see.
Yes, Panos. Report, yes.
Any criminal case was instituted against you?
No.
A copy of the inquiry report was given to you.
Not only that, Lordship, yes,
Mr. Ghosh, we are coming to you. You please have a seat. Why are you getting excited? Please relax. Here, the counsel arguing. Sit down. Yes, Mr.
It is not regular inquiry, my lord. Preliminary inquiry.
Forget it. Was a report of the inquiry committee conducted, given to, which is reflected in the show cause,
Yes.
given to you?
No, my lord.
Then what is the additional affidavit you have filed? Bringing on record the extract.
My lord, regarding the reply I have submitted, my lord.
No.
Preliminary inquiry that is given, my lord.
You come to your additional affidavit.
Yes.
Page 34, para 2.
My lord, this is the preliminary inquiry, my lord.
No, that is, you say it's an inquiry reference to the inquiry in the show cause notice.
Yes, my lord. Preliminary
Now,
inquiry.
be that as it may, that's just an inquiry report. You had a copy of that when you submitted your reply.
Yes, my lord. Basing upon this, my lord, I have submitted my reply that has not been
So
considered.
it is not a case that the inquiry report was not given to you. Inquiry report that they have relied
My
upon.
lord, to tell where is we are challenging the total system, my lord. They did
We'll
not
come to the
make
system. We'll change the system as gradually we go ahead. But first, let us understand your case. You were given a show cause. In the show cause, it was said that basing on X report, we are doing this, we found this, and we are going in. You received a copy of the report along with that, right or wrong?
Final inquiry I didn't receive, my lord.
Who has made a final inquiry?
This is initial inquiry, my lord.
That is the initial inquiry. Come to the show cause. 5/1/2023. 5/1/2023. Same one.
This I have received, my lord. That's why I have
Ah,
written.
that is the basis of your complaint.
Yes, my lord, this is the.
And the
Now, what happened there?
termination order also is
In this
based on
also,
that.
my lord, one thing,
Chaudhary, I'm trying to understand.
Yes.
The termination order is also based on 5/1/2024.
Yes,
Right?
yes.
Now you.
my lord, as per the, one of the Supreme Court judgment, Sawai Singh versus 1986 3 SCC, my lord, the allegation must be specific. Here in there, no specific allegation made against me, my lord. And on the basis of this alone, their termination cannot sustain, my lord, as per the Honorable Supreme Court.
1986?
86 3 SCC 454. The specification, my lord.
That should not be vague.
Yes, ma'am. So this is on the, our basic contention of this petition, my lord, is that the inquiry is done behind the back of me. I did not get any sufficient opportunity to substantiate my lord, what is the grievance originally, where in which a scheme misappropriation has been found against me. That is not in PIL. After, in reference to the PIL, my lord, the inquiry conducted, and in the inquiry conducted, my lord, it is clearly written that you have been found involved in such number criminal such number inquiries and misappropriation, and this alone, only this. So in this ground, my lord, I refer this judgment of 1986, my lord.
I'll do, we'll submit. Yes, Mr. Ghosh.
At the
What is
outset,
the basis for terminating the services of the petition?
Chief, on factual basis, pursuant to the direction of the court in the PIL, an inquiry was conducted.
Where is the order of the PL?
Lordship, that order I do not have with me, Lordship.
What is the number of the PL?
Lordship, 80 of 2021.
50 or?
80 of 2021.
Report said that you conduct an inquiry,
Lordship.
whoever is guilty, terminate them.
No, Lordship, not beyond that. An inquiry was conducted by the concerned commissioner. In that inquiry itself, in the on-field inquiry, the petitioner has also participated and submitted his parawise reply to that. So pursuant to that, an
Where do I
inquiry.
get that? It's not there in your affidavit.
Lordship, may peruse page 6 of the petition statement.
And annexure 8, my reply is also there. Parawise reply.
Para 6.
Lordship, page 6, that would be para 4, part of the para 4. In the last part, it is also pertinent to state that here that during the course of hearing, the petitioner had also.
This is nothing. This is nothing. Some proceeding he appeared that he said that I have not done it. That much only.
No, Lordship, it is not that the back-ended inquiry was conducted. He participated.
Back-ended inquiry. This is like some against some accountant. He's not the accountant. He's the accredited engineer.
Lordship. No, the petition was also part of the all, but along with others also.
There is no natural justice.
No, all I'm trying to say that the contention that there was a back-ended inquiry is not true because
Today, just a wild example. You both are arguing. We are arguing against or something against Mr. Chaudhary. Therein, Mr. Chaudhary makes some utterance that Mr. Ghosh is also involved with me. Now tell me. Mr. Ghosh is also involved in this matter. We punish Mr. Chaudhary. Can we also, in the same order, punish you without any reference to it? If you say yes, record it, I proceed.
Lordship may peruse.
This is what is happening. You proceed somewhere against somebody, somebody says something. You ask Mr. Chaudhary to go home. How can that be?
Lordship may peruse.
Where is the records? Processing.
Lordship, the records are not with me.
Get the records tomorrow. Tomorrow. Wednesday. Get the records.
But on the other count also, which has fallen from your Lordship, whether Article 311 along vis-a-vis.
This court, many things will flow.
No, I'm trying.
It was for Mr. Chaudhary, not for you.
Lordship, what I'm trying to impress is that there is a decision of the Honorable Division Bench also. wherein it was held that unless the contract party specifically states that the rules, Assam Services disciplinary rules are, Lordship.
That was with regard to which service?
Lordship, that was a contractual service too. Flag 3, Lordship. Lordship may peruse para 10. Ten, 11, 12, and 15.
But here, the single judge had reinstated the matter. That was upheld.
That was upheld, but the specific contention that with 311 regular inquiry, Lordship, there are other two judgments also that I am relying upon. Lordship may take up the first flag. Para 20. If I may read it, Lordship.
Anything more?
There is another one judgment, these three judgments.
But Mr. A.Y. Mr. Chaudhary, we are going against you. But Mr. A.Y. Chaudhary, learned counsel for the petition. Also heard Mr.
A.K.
Ghosh, learned standing counsel, Panchayat and Rural Development Department. The petitioner in the present petition has essayed an order dated 13/7/2023 issued by the Commissioner, Panchayat and Rural Development Department, whereby the contractual engagement of the petitioner as accredited engineer under Katigora Development Block of Kachar Jilla Parishad was terminated. As projected in the petition, the petitioner was engaged as an accredited engineer while a communication dated 2/3/2019 issued by the Commissioner, Panchayat and Rural Development, Assam. The petitioner on a such engagement was posted to Katigora block in the district of Kachar. So, in terms of the stipulations made in the said communication dated 2/3/2019, the petitioner had executed a agreement with the respondent authorities on 7/3/2019. So, in terms of the said agreement, no period has been mentioned here. Mr. Ghosh, any period mentioned?
Regarding the contractual period, Lordship, well, it has only been mentioned in the first contract, that is 364 days, I believe.
Huh?
Duration of contract, page 18, the first contract, the initial one. Page 18, pointer clause 3. The order of contractual employment or maximum of 364 days.
So, in terms of the communication dated 2/3/2019, and after having executed the agreement on 7/3/2019, the petitioner resumed his petitioner discharged his duties as an accredited engineer under the respondent authorities. Also, the respondent authorities materials having come to the knowledge of the respondent authorities with regard to commission. With regard to commission of irregularities by the petitioner herein, while discharging his duties as an accredited engineer, comma, on contractual basis, bracket, comma, comma. The Commissioner, Panchayat and Rural Development, Assam, proceeded to issue a show cause notice dated 6/5/2023 to the petitioner. In the said show cause notice, a reference was made to an inquiry report dated 5/1/2023 and an inquiry report dated 23/9/2022. By basing on the said inquiry reports, allegation was leveled against the petitioner that without implementing the works involved properly, he has been found to be involved in gross irregularities and misappropriation of government fund. Accordingly, the petitioner was directed to submit his written explanation along with all relevant documents, if any, as to why his services shall not be terminated as per the terms and conditions laid down in the contractual agreement. The petitioner responded to the said show cause notice via his reply dated 25/2023, inter alia, denying the allegations leveled against him. The respondent of the Commissioner, Panchayat and Rural Development, Assam, being not satisfied with the reply submitted by the petitioner in the matter to the show cause notice dated 6/5/2023, proceeded to issue an order dated 13/7/2020, terminating the services of the petitioner as accredited engineer by invoking the provisions of clause 9 of the contract agreement executed by and between the petitioner and the respondent authorities. The petitioner, in lieu of notice, was forwarded with 1 month, in lieu of notice, his salaries for 1 month was forwarded to him. Being aggrieved, the petitioner has instituted the present writ petition. Mr. A.Y. Chaudhary, learned counsel for the petitioner, by reiterating the facts noticed herein above, has submitted that while a serious allegation of commission of misappropriation, serious allegation including an allegation of misappropriation of government money came to be leveled against the petitioner herein, the respondent authorities had not furnished to the petitioner requisite materials basing on which such allegation came to be leveled against the petitioner. Mr. Chaudhary has further submitted that the allegations leveled against the petitioner's notice is vague to the core of it, and it could not have been expected that the petitioner would be in a position basing thereon to submit an effective reply thereto. However, in spite of the prejudice so caused to the petitioner on account of the allegations leveled, the petitioner had filed his reply dated 25/2020, proceeded to deal with the works the deal with the proceeded to highlight the manner in which he was performing his, and for the purpose had also highlighted the projects wherein he was so engaged. Mr. Chaudhary submits that from a perusal of the first reply here that the petitioner was not in any manner connected with the allegation of misappropriation of money with regard to projects wherein he was so engaged. Such allegation may be available against persons who were involved in the execution and not the petition. There is no direct material brought on record implicating the petitioner with the allegation of failure to implement the works properly and also misappropriation of government fund. Mr. Chaudhary further submits that the respondent authorities without a due and proper appreciation of the contentions raised by the in his show cause reply proceeded to conclude that the reply submitted by the not satisfactory. He submits that there without further recording reasons as to why the show cause reply submitted by the was found to be not satisfactory, and or as to what were the facts that the petitioner, what were the allegations the petitioner failed to deal with in his show cause reply, proceeded to terminate the services of the with immediate effect. 13(7) with immediate effect. Mr. Chaudhary submits that the order dated 13/7/2020 is a cryptic one and the same, not having disclosed the reasons for basing on which the respondent authorities had arrived at the conclusion as contained therein. The submits that the order dated 13/7/2023 and it an interfere. In support of his submissions, Mr. Chaudhary has relied upon the decision of a coordinate bench of this court in the case of Syed SHAYED Masood Majumdar versus State of Assam and others, order dated and other connected matters, order dated, judgment and order dated 24/6/2025 in WPC number 1093/2020 and other analogous. Mr. Chaudhary has also relied upon a decision of the Honorable Supreme Court in the case in the case of so and so reported in 1986 3 SSC 45. Per contra, Mr. A.K. Ghosh, Learned Counsel for the Learned Standing Council, Panchayat and Rural Development. On the date the order of termination was issued to the petition, and also on the date when the show cause notice was so issued to him, the contract entered into with the petitioner by the departmental authorities was not a subsisting one. He, by referring to the contractual agreement, by referring to the agreement executed between the petitioner and the respondent authorities, more particular dated 7/3/2019, more particularly to para 3 thereof, has submitted that the said contract had mandated that the period of contract, said agreement had mandated that the contract would be in currency for the period as mentioned in the agreement and for a maximum period of 364 days, whichever is more. He submits that the said agreement not having been renewed thereafter, which is renewed thereafter, the contract entered into with the petitioner is to be deemed to have lost its force on completion of 364 days from 7/3/2019. Accordingly, he submits that in absence of a contract subsisting between in the matter, the claims made by the petitioner in the present writ petition, including the claim for an interference with impugned order dated so and so 13/7/2023 would not mandate a consideration on merits by this court. Mr. Ghosh further submits that the petitioner being a contractual engagee, the provisions of Article 311 and for the purpose, the provisions of Rule 9 of the Assam Service Discipline and 1964 would have no application to him while considering a misconduct, while considering the issue of a misconduct committed by such contractual employee in the organization. He submits that the provisions of Rule 9 of the rules of 1960 would have attracted the case of the petitioner in the event the said rule was so incorporated in the agreement dated 7/3/2009. He submits that in absence of such provisions of rule, so in the agreement dated, so the applicability of the same to the petitioner cannot be presumed. Mr. Ghosh further submits that the principles of natural justice mandate that the materials having come on record with regard to the irregularities committed by the petitioner in charge of his as an accredited engineer on contractual basis, a notice was mandated to be issued to the respondent, to the petitioner, highlighting therein the materials basing on which the decision, basing on which it was proposed to terminate his services. Mr. Ghosh submits that such a show cause notice, along with the inquiry report relied upon therein, came to be furnished to the petitioner. He submits that the learned counsel for the petitioner has not disputed this position with regard to being furnished with a copy of the referred to in the show cause notice. Mr. Ghosh has submitted that the said show cause notice is to be read with the inquiry report, and on a like reading, it would come to the forefront that that materials exist to draw a conclusion of commission of irregularities by the petitioner in discharge of his services as an accredited engineer. Mr. Ghosh further submits that the reply submitted by the petitioner in the matter was duly reckoned by the respondent authorities. After such a reply submitted by the petitioner, given its due consideration, that the respondent authorities proceeded to pass the order dated 13/7/20. In support of his decisions, should I rely on this? Because then I'll have to maybe, okay, fine. Relies on the decision of the division bench of this court in the case of State of Assam versus Iqbal Hussain Loskar, WA 361/2025. Order dated 7/1/2026 in WA number 361/2025, and the decisions of the Bombay High Court, Jharkhand High Court in Jharkhand High Court in the case of Ajay Kumar versus Jharkhand, reported in 2025 SSC online JHAR 3186 bracketed DB, and also the decision of the Gujarat High Court, Jammu and Kashmir High Court, in the case of Abid Ahmad AHAMAD Ganai versus Union Territory of Jammu Kashmir, JNK and others. Abid Ahmad Ganani, GANAI versus Union UT of the JNK and others, reported in 2023 SSC online JNK 365 bracket SB. So, in the above premises, Mr. Ghosh submits that the petitioner submits that this court would direct the respondent authority to reinstate the petition as an accredited instrument and to continue in services. I have heard the learned counsel for the parties also peruse the materials. Next, heard the learned counsel for the parties at length. Hearing concluded, registered to list this matter again on so and so. 22/4/2020. Delivery of orders. Reduce my work. Let us see that judgment I want to. I'll go through my Lord Justice Suman Shyam's judgment also. That we'll see. Mr. Ghosh, not very easy. Contractual employee. There is a principle. What is the stigma? Do you know? Stigma is nothing. Today he is under you. Tomorrow he goes and joins Mr. Kaushik. Organizations, Panchayat, education. He will disclose that I was working in Panchayat. Then Mr. Kaushik will write to you that we have an employee who have come. How was his work there? How is his antecedents, everything? You will refer to your records and then you will say, oh, that man borrowed money here. So we chased him away. We have terminated his services. Then will Mr. Kaushik keep Mr. Chaudhary? No. That is stigma. You get my point? That is the place where the thing happens. If you have a departmental proceeding or if you have a proceeding done, you have materials coming on record wherein this thing is proved, at least preponderance of probability, it is established. So you writing is, but say without just in the periphery, if you move and come to that conclusion, that will be a vault for him for his entire life. That is stigma. Yes. Madam, have you gone through the order of the coordinate bench?
Coordinate bench, that's why, my lord, I have filed an affidavit in additional affidavit comparing the judgment and our case, my lord. Here, my lord, factually it's totally different. If your lordship refer to para 4, sub-para 2 of the judgment, my lord, that these petitioners were terminated from their services under separate orders during the year 2009-2010, treating them to be illegally, irregularly appointed teachers inasmuch as the ground for termination were to the effect that there was no advertisement prior to the selection, there was no approval of the state level.
You had a selection.
Yes, my lord, advertise and everything.
Where,
Kindly
where?
read, my lord, my additional affidavit, para 5.
Para 5.
Page 111. Their district is Nalbari district. Our district is Darong district, not of the same district also. The petitioner respectfully got, my lord, 111, page number. Yes. The petitioner respectfully said that in the instant case, the appointment of the petitioner is against a post created originally by government letter memo number so-and-so of so-and-so, 95. The petitioner was appointed in pursuance of the advertisement dated.
You did not have a first regularization.
Regulation, 2000.
You had.
2000, yes. In the year 2000, my lord, 2005 letter was given, but my lord, letter.
So if you're.
2000.
No, Mr. If you were appointed pursuant to a selection process.
Yes, my lord.
What was the requirement of a first regularization?
There is no second regulation, only one regulation.
Just show me that.
In the read petition, my lord, then. Should I read the para 5, my lord?
No, we'll go through it. Don't worry.
All data I've given, interview date, everything. Thereafter, my lord, regulation order is on page 31. The read petition. Page 31. That the following incumbent, type copy I have given, my lord, are allowed to draw time scale of so-and-so, then under allowance as admissible under rules against junior basic training as their regular salary against the valid sanction post. The post were originally created by letter number so-and-so, brought under so-and-so, and date of effect for announcement of different. Page 31B, your lordship may see. Last line, creation of in 2000, my lord, brought under non-plan, even since 2000, 2000. Regular salary against valid sanction post.
What is the date of this order?
Date is of this order 31st
21.
March 2005. My case is different, my lord.
So you were terminated at page 36.
Yes, my lord. 12, my lord. Along with many others, my lord. General termination order. Total, my lord. 200 and my lord. 281 people. Page 40, 281 people were terminated. And my order is also different from the single bench, my lord. While instating.
Order difference will not create any right.
That is of Nalbari district. Our district is Darong. Here advertise was made, selection was made, interview was held, and select list was also prepared. And service book, GPF account, everything is open. And since his service was regularized, my lord, service book, GPF account, everything. And my lord, in that case, coordinate bench, there is all these things are not there.
Where is the order granting Binoy Sahoria?
Yes, my lord.
Pradip Sonowal, the pay for the earlier period?
Earlier period pay, my lord.
They have not been granted.
No, 2008, because we have worked for 2008.
No.
Till 2008.
You worked till?
till 2012 we have worked, but from my lord 2008 to 12. 8 we were working, 8 to 12 salary was stopped. But we were terminated on 12.
Now, here, they say that with effect from the termination 9/10/2012 till the date of issue of this so-and-so, however, he would enjoy.
Necessary, my lord, because after termination, since we have not worked, we don't want that part of salary, but my lord, as certificate given, my lord, BO and DI, my lord, that we should pay, we should got, my lord, the work, my lord, period for the period that salary has not been given. Yet I have added the certificate, my lord, at page 33 and 34, two certificate. One by Block Elementary Education Officer, my lord, that certificate that so-and-so, now it's.
And you want the old pension scheme?
No.
You want the old pension coverage under the old
Pension
pension?
coverage. And my lord, they have given certificate drawn.
Yes.
Monthly salary from so-and-so from this.
Yes, yes, madam. Yes.
Yes. Lordship, my humble submission is that Lordship will kindly come to the second appointment letter, Lordship, at page 49. Page 49, annex of 14, Lordship. Lordship, here, the Lordship states, it is stated that the appointment is issued with concurrence of the finance, so-and-so, so-and-so, so-and-so.
No, one thing, along with her, there were two others.
Lordship.
They were regularized in a different manner,
Lordship.
and she was given a regular appointment in a different manner. Why?
Lordship, my humble submission would be that there can only be regularization when there is an SIU approval from.
Oh, forget it. That you are now picking it up from the judgment. That you forget.
No, Lordship.
Now tell me why? Because these three were there.
Lordship.
Imtiaz, then
Binoy Sohoria.
Binoy Sohoria, and one more. And
Pradeep Sonal. Page 48.
Pradeep Sonwal. Now, these three petitioners were covered by the same very orders.
Lordship.
Why a distinction was made with regard to this man? The others were given the retrospective effect benefits.
Lordship.
Salary, forget it. If it comes from 99, they come within the OPS.
Lordship.
Why that benefit was not given to the petitioner?
Lordship, Lordship, if Lordship will come to our affidavit at page, Lordship. Page 60, page 60, Lordship. Page 60, Lordship.
Page 60.
60, Lordship. At paragraph 5, Lordship. Lordship, page paragraph 5, that the order dated 1/4/2022 appointing the writ petitioner is pursuant to the subsequent SIU approval by the government of Assam on the basis of the policy decision. The answering report further states that the writ petitioner has already joined the post on the condition of new pension rule, and the appointment is prospective with effect to.
Yes.
1/1/2020, Lordship.
57 pursuant to an order, this honorable court had WBC 59 and 2013. Whereas the petitioner was a party in the earlier petition, that is 528/2018. Wherein, my lord, the petitioner himself have claimed, they have claimed that they have until 2012. And the termination order was not interfered with.
Where do I get it? Is it on record?
Page 47 and 48 are the orders for the other two petitioners, the other two persons.
47?
Page 47 and 48.
That we got it.
Yes.
Hmm.
It is in pursuance of the Honorable Gauhati High Court order dated 28/11/2016, passed with WBC number 559 of 2013. Don't know what this order is not.
Not the same order, no?
Yes, not the same order.
Pursuant to the policy decision, my lord, same order were passed.
Policy decision of BTC.
BTCs. And it is a division bench order. So division, after the division bench, my lord, different single benches passed the order following the division bench. That is his doubt only.
Or the subsequent order of page 49, there's a condition in.
That's why to have come to the court.
Madam, please have a seat. Young boy is arguing, let him. He is not a young anymore. Okay. Third, let us counsel for the parties at some length, at some length. Hearing remains inconclusive. I'll pass the orders on the next date of listing. Registry to list this matter again, a bond of Labishotia. 27.
Which date, my lord?
27.
27. This month.
Madam, you need not be here. It's only for my convenience I have kept it.
This month, my lord.
This one.
Obliged.
Yeah. Delivery.
But in this, my lord, we have filed our affidavit.
When today?
On Monday, my lord. It's
Last
not on
Monday.
record, last Monday, not on record. my lord.
Not on the.
Check.
Mr. B. Kaushik, Learned Counsel for the Learned Counsel standing of the Learned Counsel, Standing Counsel. Secondary Education Department submits that an affidavit on behalf of the respondents represented by him has been filed on
30.
On 3/0/2026. Want to file a response?
Yes, my lord.
Mr. S. Mitra, Learned Counsel for the petition, submits that he be granted for the 2 weeks' time to file a response thereto. I accepted. Registry to list this matter again. On 5/5/20.
Can it be 8th of May? If
8/5/2026, along with the affidavit as well as the rejoinder that along with the pleadings, along with the like on so and so quickly.
Obliged, my lord.
Kindly peruse the last order, my lord. This is squarely covered. Fojli Rabi, my lord. And
But tell me, when did your husband die?
husband died, my lord, in the year 2019, my lord.
When did he retire?
Retired, my lord, on my lord. Uh, 1994.
94. So where is the order of provincialization in his case?
But
An order would be there. He retired before the year 1999.
my lord, in the year 1999. my lord,
Mr. Padgiri, he retired in the year 1994. Order Provincialization Act is of 1999.
99.
Where is the order provincializing your services retrospectively? 1.
My lord.
2. Where is the explanation for the delay for institution of this proceeding in 2024 when your husband had died in, when your husband had retired in 1994? After 24 years, you have this thing. Dismiss it on the ground of delay and laches.
It's normal that I am seeking family pension, my lord.
Family pension, that is what is restraining me. But satisfy me on this.
As per Provincialization Act, my lord.
Where is that
1999.
order? Where is that order? It is not automatic. There will be an order. Adjustment, this, that. Show me.
kindly see, my lord, annexure 6, my lord, is a communication, my lord.
Oh.
Page 52, my lord.
Wherein,
my lord, Jila Porikhod, my lord, forwarded the, my lord, particulars to the commissioner, my lord. And subsequently kindly see page 53, my lord. There is a list, my lord.
You're not held to be having the qualifying service. But show me the order.
Qualifying service, my lord, reflected 13 years, my lord. Though, my lord,
Oh, you show me the order by which you were covered by the Provincialization Act. There has to be an order.
But, my lord, as per under the Act, my lord, I have service was.
Every
provincialized,
case
my lord.
there is an order, but where is your order?
My lord, I have.
And why the delay? Why the delay?
Delay is a continuous cause of action, my lord.
Fine,
Delay is
very
not,
good.
my lord.
94, but you tell me the delay. You will not get the areas.
Act was passed in the year
You will
99.
not get the areas, Mr. You will not get the areas for prior to 3 years from the date of the filing of this case. Tarsem Singh.
Is not applicable, my lord.
Yes, it will be
Continuous
applicable.
cause
I
of
will
action,
apply
my lord.
because of the inordinate delay. I'll apply.
But I have placed, my lord, on next date, my lord. Regarding, my lord, pensionary benefit, my lord,
This is
delay is not applicable,
is
my lord.
unexplained delay. It may be family pension.
Due to delay of.
You were, sir, you had no problem. Yes, Mr. Ghosh. How was his services provincialized? On when was it provincialized? Because he retired before the act came into being. Act has retrospective effect. How was that act applied in his case? In the case of the petitioner's husband?
Yeah, I'm little unequipped with the instructions, Lordship.
We are allowing the application on your default.
No, Lordship.
From 1994, you pay him the pension now. What is this casualness you are taking? This matter is pending. We have been issuing notices after notices. Your body, you have not have had time to file an affidavit when the matter pertains to the public money.
I understand that, Lordship. Just final
I want the instructions on Tuesday. Complete instructions. If not, your secretary, commissioner, everybody will be.
Lordship, for the impending elections,
Forget the elections.
Lordship, it's very tough.
We will not.
to obtain the
We don't know.
instructions. Can it be after the
No.
vacation, Lordship?
What? We gave you time enough. Why? Whom had you communicated the orders? Requirement of this one? Tell me.
Lordship, I do not have the letters with me.
Get it. I'm here. Get it. Whom did you communicate? I will get that person here and explain why the instructions were not given.
It might be on our default also, Lordship.
If it is your default, we will penalize you. Because the lady is without pension, 1. 2, we find there is a abnormal delay in the matter. But pension, it's a recurring cause of action. And the man had retired in 94. Act came in 99. How was this? It applies. But how was it applied? I wonder. Tomorrow to Bondo.
Kindly see, my lord, page number 16, my lord.
Thursday.
Lordship, can it be
Thursday
after vacation?
Bondo. So Bondo. Election.
This
Ordering election.
my lord.
Okay, 21. On the next date of listing, so this court in the present writ petition had granted time to the respondents to place on record their stand with regard to the claim made by the petitioner. The matter had also was also placed before the mediator. However, the mediation had failed. The respondents had not brought on record their stand. While order dated 23/2026, noticing the submissions made by Mr. A.K. Ghosh, learned counsel appearing for the PNRD department, 10 days further time was granted to complete his instructions. Mr. Ghosh today is without his instructions. Also, matter involves the family pension of a senior citizen. Accordingly, this court fixes the matter on 27/4/2026. If on the next date of listing, the instructions are not furnished, the Commissioner shall remain present before this court. Commissioner Panchayat and Rural Development shall remain present before this court along with the contemporaneous records to assist this court to dispose of the present writ petition. This is not called for. You're a young guy. I don't want to impose cost on you.
This matter I have been.
Mr. Ghosh, likha. Mr. Ghosh, shall download a copy of this order and forward the same to the Commission, Panchayat and Rural Development for compliance.
Maybe, Lordship, this matter I have been newly engaged.
Which one?
This 16. I'll be filing wakalatnama matter.
Oh, we'll help you. We'll help you. Miss Wanglapa, is it? We'll hear. Show me.
I cannot show anything, my lord, because file I have got in the morning.
Don't just parachute in like this. We'll not accept that. Matter is there. She is there. She will argue.
No, there was another briefing council, my lord. He left, my lord.
Oh, you have asked him also to go.
No, my lord, he himself went away. I was in court 7.
Mr. D. Gogoi, learn it. Counsel submits that he has been engaged in the matter by the petitioner today and accordingly prays that the matter be listed on when?
After Bihu, May's first week.
May. On 7/5/2026.
Right.
So he submits that on the next date of listing, he shall make. You have filed your affidavit.
Yes,
He
we
shall
have
make
applied
his submissions towards, but he shall submits that this court may take up the matter for disposal on the next.
My lord. Very well. Obliged.
Got anything?
My lord, after vacation, my lord. I have
Change the nature of your fate of your case.
I have found an order wherein my lordship appears, my lord.
I'm confident of this.
My lord is very.
But not
clear.
not these people.
No, for other bets.
The batches. I have got them engaged in the back to the irrigation department also.
My lord.
That is different.
That is different.
There were schemes which had come in to MIDC.
No, my
When
lord
MIDC was
yes.
created. So once MIDC was closed down, these schemes went back.
My lord.
But the people did not go.
My lord.
Gori, it is the cases of
Gaurikanto Roy or
R. Rahman. I still remember, very,
very
what do you call that? A very active, but he did not get the relief. That's a very sad thing for me.
my lord.
He passed away before that. He passed away. Then there is Gori something. They went up to the Supreme Court also. But your case is not that.
It is very tough, my lord. My lord, I have to satisfy my lordship that whether corporation employees are, my lord,
Mr.
pensionable.
let
My
us-
lord,
let us give it
I'll make a try. Actually, my lord, I could not get
Personal ground, you tell me, I'm giving you.
a personal ground. my lord.
On the prayer of Mr. A.R. Bhiyan, counsel for the petitioner who submits that he be granted further 2 weeks' time. Prepare and make his submissions in the matter, which he was not permissible on account of sudden personal inconvenience. Prayer accepted. Register to list this matter again after 2 weeks on a date to be fixed by.
No.
You want to say it by item?
Obliged.
You have not got the benefits, Mr. Yes.
Last occasion,
Ah.
Mr. B. Gogoi Learned,
Ah.
additional AG, he made a submission that it is.
Under
still under
process. What happened
Lordship.
after that? It is on 2-3. We are now in 2-4.
Lordship.
What happened?
Chip, that I will. have
Get
to
Mr. Gogoi.
Hold of him, yes, Lordship.
Mr. Chetri is waiting here for the whole day.
Lordship.
How can you allow a senior person to be here for such a long?
Chip, I will-
Get it. Mr. Chetri, just wait for some time.
Lord, in terms of the direction, we have filed our appeal in opposition, but copy could not be served because he was not found available. Lordship, right now, the
You
copy.
could have sent him in his mail. You could have taken his mail and you could have sent
No,
him.
right
You could
now,
have sent him in WhatsApp.
Right now, we can serve.
Your Honor,
Mr. Locker is a tech savvy man. So he'll love, other than the paper, he'll love it there only. For people like me, paper is required.
My lord, right now, my lord, we can serve, my lord.
You give it.
Yes. I'll accept it. Your Honor, matter is such that I am owner of this college.
No, do one thing. They have brought this affidavit. I found that there is something. Just file us. If you don't want to file, just go through it. We'll have it next week, no problem. And then we will take it. You are in Gauhati only?
Yeah, I'm here.
We'll take it up next week and we'll go over.
My lord.
Heard Mr. Vikram Singha, law court, petitioner in person. Also heard Mr. S. Chamaria, learned counsel, appearing for the respond number 5 and 6. Mr. Chamaria submits that an affidavit was filed on behalf of the respondents represented by him. However, a copy could not be served to the petitioner as the petitioner was not found available. Also, he has submitted that a copy has been furnished to the petitioner today. Mr. Bikram Singha Law Court, learned. Bikram Singha Law Court, petitioner in person, submits that he would peruse the affidavit and make his submissions thereon on 8/4/2026.
Obliged. Maybe at 2 p.m. or.
Please don't, please, no problem. Understanding 2 p.m.
No problem. Deeply
No problem.
obliged.
At 2 p.m. At 2 p.m. But Mr. Locker, one problem. It is just before Bihus. 9th is from 9th we are having holidays. 11th we don't have food. From 9th, then the 9th afterwards we don't have food.
Thursday.
You better take it on 20th because that would be a motion week. And we will be flooded with cases, motion cases. So we may not have
Before
time.
it is no problem.
20th?
Lordship, there is a problem like.
Okay, we'll have it on it. Don't worry.
Obliged.
2 p.m.
Obliged.
Lordship, in this matter, on before the, I have filed one affidavit in opposition which has not been tagged, Lordship. I could file it today only, Lordship.
Okay.
I have filed affidavit.
Huh?
Can it be taken up on Monday, Lordship?
You call for that affidavit.
Okay, Lordship.
You have given a copy. You have filed a affidavit. What is the?
With the stand is the person is not of any political party at the time of admission
You have
and the
45
selection process.
You have also filed an affidavit. Okay. The learned counsel, and this reply is against which one? The earlier affidavit.
My lord.
Earlier affidavit.
Against my private respondent. Affidavit.
Okay. Miss, your affidavit also is not on record.
Record, my lord. Already in record, my lord.
My one is not
Both.
in record.
No, my lord. Government affidavit is not on record.
No affidavit is in record. Only the writ petition and your affidavit in reply is in record. The affidavit in oppositions filed are not on record. When did you file, Mr. Doctor?
We have filed on 23rd of March.
Extra copy দিয়াই দিম লৈ পেলাই তোক দি দিম মই ডাইৰেক্টলি নাই নাই ফ্ৰী আছে
Affidavits are not on record. Only the reply is on record. Miss M. Bachaji and Mr. P.P. Dotto. Ms. M. Bachaji, additional senior government advocate, appearing for the state respondent, and Mr. P.P. Dotto, learned counsel representing the respondent number 6, have submitted that an affidavit on behalf of the respondents represented by them has been filed. Mr. Padgiri has brought on record a reply filed by him to the affidavit filed by the respondent number 6. However, the affidavits filed by the state respondents and as well as the respondent number 6 is not on record. Registry to trace and tag the affidavits filed by the respondents along with the records of this case and list the matter again on 30/4/2026 for further hearing.
Deeply
Obliged.
obliged, Lordship.
Yes.
Earlier matter was hard, my lord.
Huh?
Earlier matter was hard, my lord.
By me?
Yes, my lord.
Huh. But then we had to adjourn this because Mr. Burah had gone out. Yeah. Okay, it's tied up. Tied up matter. Huh? Registry to list this matter again after the ensuing Bihu vacation.
Matter is regarding admission.
Huh?
Matter is regarding admission, my lord.
Admission is over. Admission is over. Now only compensation. ठीक है sir, registry to, as agreed to by the learned council body parties, registry to list this matter again on 23/4/2026.
Otherwise, my lord, that he is not eligible in terms of the.
That we will see.
Yes, my lord.
Admissions are over?
Yes, my lord, it's over. It's over long back, my lord. Problem.
Yeah.
Most of it.
Pay scale matters will wait after the vacations. As agreed to by the learned council body
This is
parties.
the pay scale matter, but the one anxiety I have that I'm not sure of it. The pay commission is
Oh, that you make a prayer. Pay commission is already on in the anvil. As agreed to by the learned council body parties, registry to list this matter again on 7/5/2026.
Deeply obliged.
May please, your lordship. Lordship, the petitioner filed an RTI seeking certain information.
Yes, wait, disposed of.
Your lordship.
Second appeal disposed of.
Yes. Your lordship, Dideka had to leave as he had to attend some personal difficulty.
Attend some personal difficulty or due to some personal difficulty?
Pardon, your lordship.
He went to attend some personal difficulty or due to some personal difficulty he went?
Due to some personal.
Due to some. He went home.
Yes, he was here this morning until.
Otherwise, people will think that his difficulty is in home. Personal difficulty. He went. Just banter. Let Mr. Deka come. A prayer is made on behalf of Mr. D. Deka, learned counsel for the petitioner, for an adjournment in the matter on the ground that he had to leave the court due to certain personal inconvenience. Prayer accepted. A registry to list this matter again on 30/4/2026. On the next date of listing, Mr. Deka shall apprise this court as to the status of the second appeal referred by the petitioner in the matter.
Much obliged.
Deeply obliged, lordship.
I am appearing on behalf of Mr. H.K. Das.
Ms. D. Mohanto is present on behalf of the respondent number
3, lordship.
3.
Much obliged.
Registry to list this matter before 26. Registry to list this matter 26. 26. No. Item number 26. It to 3 tarikhe disa. It to item number 26 likha. Registry to list this matter before any other bench without me. Bracket. I appeared in the earlier round of litigation.
Merci, Your Lordship. The petitioner has challenged his rejection of his candidate, Your Lordship. They have filed their affidavit in opposition. I'll just take your lordship to.
Ready for disposal?
Yes, lordship. On 5/9/2024, lordship. They
Now
issued
tell
the
me.
advertisement.
I'll
just take your lordship to page 22 for a moment.
20?
22 for a moment.
22.
Yes, lordship. The clause 6.1.
6.1, huh?
Yes. Mary, lordship. Candidates who wish to be considered against reserved vacancies or seek age relaxation are required to submit the requisite certificate from the competent authority in the prescribed format. When such certificates are sought by the CAPF concerned for document verification at the time of DME. Otherwise, their claim for SC, ST, OBC, EWS, ESM category will not be entertained and their candidature applications will be considered under the unreserved category. Further, if a candidate has sought any other relaxation or claimed ESM status and is not able to produce the relevant certificate, he will be considered in his respective category, that is SC, ST, OBC, EWS, PUR. The formats of the certificates are annexed with the notice of the examination. Now, I'll take your lordship to page number 80, the format which is prescribed by the respondents.
Just a moment. Ms. Burah, where is that prescription in the advertisement that the certificates have to be of a particular date?
No, that is
That
6.5.
is 6.5 and 6.6.
Page number 22.
Okay.
6.5.
It says that a crucial date, they have fixed a crucial date, 14/10/2024. The candidate must possess the caste certificate in the format prescribed by the respondent, which is annexed at page number 80, lordship.
80, 80.
Yes, 80.
Yes.
This is the format in Annex 7. This is required to be submitted at the time of document verification by a candidate who claims OBC status because he
NCL.
NCS. Now your lordship will find the certificate at page 90 in the prescribed format. That is dated 10/9/2024, which is before the crucial date as fixed by clause 6.5 of the advertisement. 6.5 says 14/10/2024 is the limit crucial date, and it is on 10/9/2024. Now, in the affidavit in opposition, they say, lordship,
Yes, yes, Ms. Burah.
Yes.
What is the error committed by him? Huh? Where is the period of limit, that period of,
Next, they have
Madam, forget that. Where is the period that your format prescribes that this should be valid for a year or 2 years or 3 years? Where is that? And where is your original NCL certificate? This is a form, thappa.
lordship,
Where is the original NCL certificate?
that I have not annexed it,
You will have to have a certificate prior to this date.
lordship.
This is copy paste of that.
Yes,
Where is that certificate?
that certificate at present I do not have. But this is this
This
10/9/2024.
signature we understand
Lordship,
format, but the authority will have to sign here
lordship,
basing on an NCL given to you.
lordship.
So where is that NCL? Prior to 10/9. What is the date, date of your thing?
10/9/2024.
10/9 something.
I have not annexed it because it was the
10/9/24.
It is
This will not do.
Yes, yes.
When there is a dispute, we will want the original.
No, they say, lordship, in their affidavit in opposition at page number 95, para number 5, they say that there is a requirement fixing that the certificates has to mention the validity period.
That's true. That's true. We have seen it.
And that notification in respect of the validity period was introduced on 6/11/2025, that is March after the
Okay,
recruitment policy.
forget it. Where is the original basing on which this certificate was issued?
That I have not annexed, lordship,
You will have it, your petitioner will have it.
because this your lordship will find page 108, this is another certificate.
That is after the.
Yes, that is for the next financial year.
Where is the certificate prior to issuance of 10/9/24?
That certificate.
This is not a permanent resident certificate. There will be a requirement for a examination. There will be your affidavits. Thereafter, this is not preceded. This is just a signature given
Lordship,
by following that. Where is that certificate?
I have just annexed the or some other backward class association.
That is, we got it.
At page 60.
But where is that certificate?
That certificate I do not have at this moment.
Because here, this certificate is not a certificate issued after processing.
Lordship,
This is a certificate issued by verifying These certificates you already have.
Yes.
OBC certificate and NCL certificate.
Lordship.
Basing on that, this is done. Produce that 10-9.
Well, it is 10/9/2024. He produced it for the 2024 recruitment. This certificate at page 90. So I'll have to collect it from him.
Wherever it's.
Lordship.
Just show me the certificate issued to you
Lordship.
prior to this endorsement on 10/9/24.
Lordship.
Nothing more is required.
The requirement is not only the certificate, Lordship. In my respectful submission, the requirement is the income.
Mr. Counsel,
Lordship.
this certificate, there is a procedure for issuing a,
Yes.
a OBC certificate.
Yes.
There is a procedure for issuing a NCL certificate.
Lordship.
There is a verification done.
Lordship.
Show me where the verification is done here.
Lordship.
Show me from this. Show me that this is a certificate issued after verification. Your status.
No, that is not there.
That means this is issued basing on an NCL certificate you already have.
Lordship.
OBC certificate you already have.
Or on the basis of the income certificate.
No, cannot be.
Because the income
They
of the
cannot be. He
preceding
does not
year-
have the power. The executive magistrate does not have a power to issue a NCL certificate. It has to be issued by the Deputy District Commissioner.
No, the notification is there. The executive magistrate can issue.
Which one? NCL certificate.
NCL certificate.
Show me. Where is that exclusion of the director? Where do I get it here? That the certificate is to be issued by the executive magistrate?
Lordship, for the purpose of verification of
Verification is different, Mr. Counsel. In the light of so and so, Supreme Court, that para 2, right? You have a copy of this? The one you gave me now.
Lordship can check this. I have highlighted it.
This is not
1993 notification. How? Serial number A, your Lordship will find.
just a moment. District Magistrate, Additional District Magistrate, Collector, Deputy Commissioner, Additional Deputy Commissioner, Deputy Collector, First Class Stipendary Magistrate, Subdivisional Magistrate, Taluka Magistrate, Executive Magistrate, okay. Okay, accept. Now tell me how this verification was done. 10-9. You got it, so you know how you got it.
Lordship, that the district commissioner can only answer.
No, you answer because you got that endorsement in your form.
Lordship.
You got the endorsement in your form.
Yes.
What was the basis of that endorsement?
That I have not annexed because there was no dispute with regard to that.
Now we are disputing.
Lordship. In fact, the respondents have not disputed them.
I am disputing.
Lordship.
I have to pass the order.
Lordship.
Show me that this 10-9-24 certificate
Lordship.
was issued by the executive magistrate by going through the entire process that is required. And the process that is required for issuance of NCL, 24 onwards,
Yes.
Vasundhara 1 and all after that, it's online.
Lordship.
It is not physical. So how did he issue? Endorsement in a form, I understand. That can be on the basis of an existing fact, existing certificate.
Lordship.
He does it, no issue. But this cannot be the sole certificate issued to you. Prior to this, you don't have a NCL or a OBC you don't have an NCL certificate. You got my point?
Yes.
If you have an NCL certificate prior to 10/9/24, covering the period till or after 10/9/24, the executive magistrate can endorse this. No issue on that.
Lordship.
But if you don't have a NCL certificate prior to 10/9/24, for the first time in the endorsement in the form, he cannot do it.
I understood.
Get it clarified. When?
After vacation?
Monday?
After vacation?
But Mr. R. Burah, Learned Counsel for the petitioner. Mr. Burah, on the next date of listing, shall apprise the court as to the basis on which the executive magistrate, West Karbi Anglong Hamrin, had endorsed the backward or other backward class and endorsed the status of the petitioner as a backward class or other backward class community candidate and also to belong in the non-creamy layer. Wide endorsement in the format dated 10/9/2024. Mr. Burah shall also apprise this court as to whether the petitioner had a NCL certificate prior to 10/9/2024 covering the period till or after 10/9/2024. Raised it to list this matter again. 29/4/2026 for further hearing.
Lordship, there is an interim order.
Interim order passed earlier to continue till the next day. If he gets me that, we are putting him back there. This you can't do. I just want to be satisfied on that.
Lordship. Understood.
Look, Supreme Court has different verdicts where it was established that anything regarding grade pay is granted that cannot be curtailed. In Sandeep Mehta versus R. Mahadevan, JJ 2024 SC, the Supreme Court quashed a Bihar government order that reduced an employee's pay scale and ordered recovery of excess payments after a long time gap. The court noted this was grossly arbitrary and illegal and constitute.
Do you have the judgment with you?
I have not taken, just I will give.
Why you bring the judgment also?
Later on.
And Mr. Kulta, we have a division bench judgment on this point.
No, I have no division. Yes.
No. There is a division bench on the point.
Yes.
Of a primary school teacher.
Yes, my lord.
Getting a graduate scale of.
Graduate scale.
You are an intermediate teacher. You may be a graduate.
Yes, my lord.
But for recruitment to your post, graduation was never a qualification. So the authorization of 8,700
in the year 2016,
6,800 was only on the ground that you are a graduate.
Graduate teacher.
Graduate teacher, graduate qualification and graduate teacher are two things.
Yes.
Division bench has considered that aspect of the matter and has said, no, you are not entitled. Bound by the division.
But they are provided with the grade pay in the year
Say that
2016.
whatever has been provided to you.
In the year 2016.
Don't recover.
Cartel in the year 2025.
Mr. Kolita, in fact, what you drew as 8,700,
yes, my lord.
They will not touch it, but you will get it as 6,800. They will not recover. I'll prevent them from recovering.
But for a long time, they were provided with the
Get it?
grade pay.
However long time you have got, I will ensure that they will not recover that.
Supreme Court has different
Subject to
judgment,
appeal.
but I have the numbers, so different judgment in Supreme Court, my lord.
We should have been armed with that. Now we can't. I will say follow division bench.
And the
say-
decision was also taken subsequent to the decision.
And I will say that the authorization of 8,700 to you for the period it was authorized will not be recovered, but you will be deemed to have drawn 6,800. Agreeable? Not agreeable.
Nothing.
On the
because
prayer of the
different-
land council for the petition,
If-
raised
if-
it to
if
list
one-
this matter.
That, my lord, I
Uh,
will submit the. Supreme Court
Raised it to
judgment.
list this matter again after the ensuing Bihu vacations on a date to be fixed.
Obliged, my lord.
Yes, yes, Mr. Borpuzari, what happened? Even benefit.
No, no, my lord,
Why?
it is under consideration.
Under consideration, why so long?
Because
Under
my lord,
consideration where?
my lord, in our department.
In your department
Yes,
means?
my lord, finance.
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 Why is the finance taking so long?
Because my lord, the data was called for from the administrative department concerned.
That data you call for on 2-3, before 2-3.
My lord, there were some shortfall, my lord.
No.
And
This person is working. He is covered by the. Where is the earlier order? Of this court? Page 36.
Page 30.
36.
Relieve in portion, page 38.
Yes, after this, what is left? Have you gone on appeal?
no,
Then this order is of 21. Till date, the petitioner is not getting anything. If you have not read it, Mr. Borpuzari, you can read it for 10-15 minutes, then we will take it up.
no, my lord, I have read it because this is the instruction. My lord. I have.
We will not accept that. For the last 5 years, what were you doing?
That's it, please.
Okay, we will impose interest and then we will do what is required. Poor worker against the mighty state.
Because those names were not said, my lord.
You should recover it from the officers who are at default
no,
in
there
not
is a-
complying with the orders for
there-
the last 5 years.
There is a procedure laid down, my lord, that we have to
It
follow.
does not take you 5 years, Mr.
No,
Or if you tell me that your procedure will take 10 years to complete, we will record it and list the matter after 10 years.
No, if your for a moment, if lordship comes to page 38 of the writ petition, that is the earlier order passed by this honorable court. What was the my lord, direction? At paragraph 8, accordingly, in the light of observations made by this honorable court in paragraph so open thus, the court is inclined to direct the same protection and benefit scale of pay which is presently in force in terms of so along shall be extended to the petitioner along with other master roll workers, workers, employees, and similarly placed so and so. We hope and trust that the concerned respondent authorities shall do the needful so as to extend the benefit of the minimum scale of pay to the petitioner with effect from 1/8/2017 along with area pay, etc., preferably within so and so. So there is the direction is made collectively, my lord.
I got it.
Now, my lord, it is.
I got it, Mr. Borpuzari.
Yeah.
What were you doing after the order for the last 5 years?
We were sitting, my lord. We were in anticipation of the proposal because he is not our employee, my lord.
Why are you taking the bull by the horn? You sit down, let the concerned department who had to give the proposal.
Now,
Forget it. Who is the concerned department?
Women and Child Welfare Department.
Which is the Women and Child Welfare. Yes, madam. Why the proposal was not given?
Because he
For the last 5
he is
years.
not our employee.
Okay, that's
their employee.
I thought you were appearing for all the government departments. You move out. Yes, come. Why?
Instruction I don't have right now.
Get it. At 6 o'clock, we will take it.
No, Lordship may fix it.
No, today, 6
evening,
o'clock.
At least 2 days time.
No,
Lordship.
why? For the last 5 years, what were you doing?
Because Lordship, the file also. has
The
been
office is
fixed,
just
Lordship.
behind.
Yes, Lordship.
Call up, or you go or send someone. Get it in 15 minutes. When was the proposal sent and why the proposal was not sent earlier? What is this? Playing around with the High Court order? Monday. The Director, Social Welfare shall on 6/4/2026 apprise this court as to the manner in which the directions passed by this court-wide order dated 24/2/2021 in WPC number 2847 of 2028 was processed for compliance. In the event the instructions are not placed before this court at 10:30 a.m., the Director, Social Welfare shall personally appear before this court at 2 p.m. to answer the queries of this court.
Now the social welfare becomes the women and child.
Women and child question? Social welfare.
Women and
It doesn't come into my mouth. What to do? Women and child.
My instruction also says, my lord, women and child.
Women and
welfare
child.
required. Lordship may be pleased to retain the-
7th.
Lordship may be pleased to retain
Seventh.
the instruction.
Obviously.
Lordship may be.
You
pleased to-
to grade you.
The finance was not even a party respondent in the earlier.
Why
round of
did you
proceedings.
make such big submission? You should have just said, my lord, I have just received it. Finished. I thought you are the main man.
No, my lord, at the end of the day, my lord.
You are the main man, finance. 7.
So,
But I don't get it. At 10:30, it has to be placed before me as the first item. 7th as the first item.
Obviously.
A man is before this court. This court has determined his right. Now you all play around with the order of this court. That will not be permitted.
Lordship, day before yesterday, I submitted one instruction with regard to the contemplation of written examination for recruitment to the post of supervisor
Yes.
against 25% reserve post.
Now that new notification
Yes.
requires that.
This
Where
is
is
the
that?
new notification.
Just-
My lord, new notification is of 24, my lord, 2024. So.
No, we'll hear you, madam. We'll hear you. Please have a seat. We'll hear you. We'll hear you. Where do I get it? That this is,
Lordship, this is notification.
five.
And B selection procedure,
So
5/6.
that 19-1 has now been superseded by this 24-1. The other
Yes.
case you produced are 19-1. You remember?
No, Lordship, that is notification dated.
Okay, that is to the post of Anganwadi worker. and,
4/6/2012.
that
That has
is
been
Angan
superseded
by this.
by this.
Yes.
My lord, by this, the recent notification, my lord. I have
Okay,
to
ma'am.
again
What is
appear,
your
my lord.
case?
I have to again appear, my lord.
What is your
for
case?
written- My case is, my lord, I've been working since 96, my lord, not
Ah.
a single promotion, my lord. From Anganwadi to supervisor.
So the earlier round of selection that you have put to challenge,
Yes, my lord.
you are giving up that challenge.
No, my lord, I
Then
had
you argue on
appeared,
that.
I had appeared, my lord. I was selected also in written case. And after that, my lord, finally, I was not selected.
No, fine. You make your submissions on that.
Yes, my lord. And as per the, my lord, the notification, my lord, of 4th of June 2012, my lord, at page 33, my lord. The oral, as per the rules and regulations.
Madam, this was an oral interview, but you participated in the written examination
my lord.
without any objection.
Yes, Lord.
Then how can you turn around and now not favorable challenge that?
If the department, my lord, holds that kind of.
I'm
my
sorry,
lord,
Madan Lal is
written
there and
case,
this
my lord.
series of judgments there are.
If this had been, my lord, added, my lord, my experience, my lord.
Madam?
Even 10 marks also added, my lord, I would have got it.
Madam, your grievance is that the selection should not have been on the basis of a written examination. It should have been on the basis of an oral interview and the marks for experience.
Not only that, no, I did not say reading a test should not have been held, my lord. I said if this had been, my lord, added, then I would have got it, my lord. I would have been selected. And experience matters a lot, my lord. I have been experienced for 22 years.
Okay. And
No,
there
it
were
should have been at least
there
considered
were
basis of
persons
my
selected
experience.
in pursuance to that selection process.
Which, my lord?
That this selection process, there were people selected,
Yes, my lord.
promoted
Promoted,
to
yes.
the post of supervisor.
Yes, my lord.
How many were promoted?
There are 284, my lord.
284.
284 candidates.
Now, who should we replace to get you in?
Not replacement, my lord. I'm not against those people who are already selected. There are other, there are so many vacancies.
Show me the advertisement, madam.
There is no advertisement, my lord. Only thing is that only the proposal is there, my lord.
Where?
Proposal of director.
Where?
I'm giving it, my lord. At page, my lord, 28, my lord. This is the proposal of.
No, how many posts were involved in that recruitment process? Only 25% is required.
Yes,
What is the
madam.
cadre strength of supervisor at that point of time?
Lordship,
So, madam, how do I know that there were vacant posts available at that point of time? You have made any statement to that effect?
My lord, in there. But that is one of the my pleas, my lord.
Madam, first let us finish, get
Yes,
that plea. If
yes.
that plea is successful, you need not go into the others.
Yes, ma'am.
Show me that these were the number of posts available and these were the posts filled up.
Advertisement, I don't have. My
Forget
lord.
it,
That is
madam.
the
You
biggest
might have made a statement here somewhere.
Yes, ma'am.
Yes, just show me that. We only want to know that there were posts available.
Only the number of candidates are mentioned, my lord.
Where, madam?
And in their affidavit, my lord, at page 4, at
Okay.
page 4. The last part, my lord, 284 numbers of candidates were selected. Only that much out of my lord, 1144 candidates. Annexure B, my lord, 1144 appeared. Out of which 284 was selected, final selection, my lord.
This much only, madam? Or anything further?
Well, illegality happens, my lord. It is apparent, my lord. Illegality happens in my case, my lord. And not only that,
How long have
I'm
you been
graduate,
working,
I'm
madam?
graduate, my lord,
Madam, how long have you been working?
since 96, my lord, as Anganwadi worker. And I'm a
96.
graduate.
On the date of the interview, how many years have you completed?
Date of the interview, my
Huh?
lord. Interview was on. I'm already. Hmm?
29/1/2016.
Yes, yes. In 16, my lord, 2016.
16. So 99,
Already 22 years, my lord.
99, 2000, 17 years.
Mhm.
What is your qualification?
I'm graduate, my lord. Along with that, I have other qualifications also, my.
Madam, how was this marks given in the recruitment examination?
Lordship, we have stated in our affidavit at page 4
That
itself,
is only 41 in English
Yes.
written and 8.66.
and the cutoff marks for selected candidate under the SC category.
How did
was
you
50.33.
factor in page 34? That is the grievance of madam.
We have annexed the comparative statement, Lordship,
Where?
at annexure B. The name of the petitioner reflects at page 47, Lordship.
Serial number. Oh, serial number.
891, serial number.
there is
At
problem with
page
him.
12, my lord.
Huh?
At page 12 of the affidavit. my lord.
12 of my affidavit.
12,
Yes.
10, 11, 12. Huh. Onudas.
Yes.
Yes,
ma'am.
Lordship. SC candidate, she obtained a total marks of 49.66. Written marks 41 and Viva was say 8.66 marks.
So what do you say about the, madam, where have you made a statement that you were not given the marks for experience
Yes.
in the writ petition?
Yeah. And moreover, my lord,
Madam,
as
just
per-
let us
as
just
per the,
complete this point.
proposal, my lord, there is no mention of any cut-off marks, my lord.
Madam, just let us get off the first point you have raised. Where have you mentioned
I have
that
mentioned-
you were not given the marks?
Yes, my lord, I'm giving it, my lord.
You have not even dealt with that, madam.
No, my lord, I have
Then
mentioned. that.
kindly show.
I have mentioned, I have filed an affidavit also in
Please,
addition. my
please
lord.
should.
Mm. My lord, my affidavit dated, my lord, 12/2/2021.
So,
My
madam,
lord, at
this marks,
my lord.
this marks has not been given to anyone.
Yes, my lord.
In the selection process, these marks have not been, they had taken an average of the marks. And then 23 is the highest, I find. And then it tapers down. So if the page 34 first category 60 marks is given, then everybody would get further higher marks. Because at least somebody will be third division.
Yes, my lord. That is-
Minimum would be matriculation third division,
Yes, my lord.
right? There would be first division also, second division also.
Yes.
You are a third division. You will get 30 marks more. At the same time, people above you will also get 30 marks more.
Yes, but my lord, there is a marks for experience also.
Experience marks also,
Yes.
it is just see 8 marks. I think that is what was given to you. 8.66. They have given you 8.66. Right?
Yes.
So, madam, that correction, that calculation is
My
correct.
lord, kindly, look at 34, my lord.
I'm
Page
34.
my lord.
Hmm.
The notification, my lord, the guidelines. My lord, for candidate past HSLC, third division, my lord. I'm graduate, but I'm taking that also, my lord, HSLC, 37 marks, my lord.
Madam, if you are given 37,
Yes, my lord.
the others above you will also be have to given 37. Nobody has got that marks. So,
And
we
this
take
does not
everybody to be
consider
third
account,
division.
my lord.
We take everybody to be third division. Moment you get 37, people above you will also get 37. Again, the position would be the same.
No, my lord, then again, experience wise
Experience.
also.
You will
Experience.
be 15 to 20. 8 marks. That has been given to
No,
you.
my lord. For length of service above 20 years, my lord.
Show me that you have before about 20 years on the date.
Is almost
99. Almost, and there it's different.
96.
99.
I joined 96.
96.
Yes.
Then,
And it was held in, written test was held.
no, when was the advertisement?
Advertisement, I don't have, my lord. There was no such
Lordship, this is
advertisement,
an
my lord.
internal promotional exercise.
Okay.
Yes, my lord. Then only on the
think they have
basis of
done
the
the thing.
proposal, my lord.
And when are you going to now hold the fresh recruitment exercise?
Lordship, with regard to that also, Lordship, deliberations were going on between the department and the
Consider
government
case of
also,
madam then.
Lordship. And a third party, preferably
Will
the
be a-
Board of Secondary Education, they have, however, rejected the
Where are the
proposal
vacant
and
posts, madam?
I have mentioned, my lord.
Where, that's what I want to see. You have mentioned of juniors being promoted,
Yes,
you
my
not being considered.
No, my lord.
So you have not even arrayed the juniors as party respondents here.
My lord, 284, my lord, candidates, it is not possible for me to.
At least if the ICDS project.
Some of them, my
Madam,
lord.
ICDS project where you're working, you
Yes,
say
ma'am.
juniors, you can come to para 10. You say juniors have been promoted. You could have made them a party as on representative capacity.
But I had met 3 of them, my lord.
Where?
Yes, sir.
Subsequently.
Yes, my lord, subsequently. IA 1050, my lord.
But no
Disposed of,
notices have been
disposed of,
issued.
my lord, disposed of.
Have you taken steps?
My lord, already disposed of, my lord.
What?
This one, my lord, the implement.
No, madam.
Implement of parties.
After the implement, have you taken steps for service of
Of
notice?
course, my lord.
I don't find that.
It was complete, my lord. It was complete.
Madam, there was no order passed for issuance of notice to them.
My lord, disposed of on 20th February 2023,
Oh,
my lord. Three selected candidates were made parties, my lord. Especially number 6, 7, and 8, my lord.
Madam, ask your junior to go through this. There is no notices issued. It remained like that.
Disposed of. My lord, this was on 28th of February, my lord, 2023.
No, impleaded, but no notices have been issued.
But we had, my lord.
You
We
fool me?
had, they refused to come, my lord.
Huh?
They refused to come, my lord. They received it, but they did not.
File, how did you? How do you took it by Dusty?
Yes, my lord.
Where is that affidavit?
Just a minute. Looking for it.
Okay, we'll have it on some other day. Heard the Ilana Council for the parties at some length, raised it to list this matter again.
Can it be after view, my lord? I've got some problem.
Whenever it's convenient to you, ma'am.
Yeah.
27 will be fine with you? 27/4,
Obliged, my lord.
2026. Yeah. As agreed to by the Ilana Council for the parties, registry to list this matter again after the ensuing vacations.
All right.
Appreciate Lordship.
Lordship, may kindly see,
Mr. Yes, Mr. Chaudhary, what is the relief you want here?
Your Lordship will peruse the order dated 24/2/2026.
We have seen it.
My lord.
And the letter you issued matches, signature matches. Is there anything more to be considered here? Are you in contact with the client? With your client?
My lord.
yes. Only thing that page number 58 of the affidavit.
What is to be done today?
Either dismiss or Lordship.
Yes, Mr. Chaudhary, you can make your submissions.
But Lordship will see, then your Lordship wanted to have, then let it the other day, your Lordship.
you're waiting from the morning here, option.
My lord,
No, no,
that's why-
we feel
that is
that.
why I am not able to argue before your lordship today, your
You're feeling, not feeling well.
my lord.
Okay.
Fix
On the
another
prayer of
date, my
Mr.
lord.
R.M. Chaudhary, learned counsel for the petitioner who submits that the matter be taken up on any other day, in
Right.
as much as he is not feeling well today. Also, prayer accepted, registry to list this matter again after the
Bihu
ensuing
vacation.
Bihu vacations.
Master bless.
Bude, Baki gini, iya guru diba. Reached. He moved but father interview. Diba. Yes, order compliant.
My lord, he,
Compliant.
no, my lord, he has submitted this letter to me today, my lord, but I have seen that it is not complied, my
Okay.
lord.
Very
Wrongly.
good.
And I contacted the petitioner also, not complied, my lord. Only the letter is issued, that is also not, my lord, correct.
My lord complied with, but it is
No, my lord.
Registry to list this matter again on Budbar. 8. You make a mention at 10:30, I'll see.
My lord.
Yes.
Chapter 41.
Sorry, I could not. The old matters in the top.
Lordship, when hearing that matter number of times, madam, can it be just after give, madam?
Any day, you just, yes, madam.
39 lordship.
Please give a date convenient. She will-
Interim.
give a interim, wherever, just tell her, she will do. Silo board interim, do the same, interim extend.
pension not received, 2017 onwards.
Next date, when it is listed, make a mention at 10:30.
What's the item number 35 and 36? May give a fixed date. Box.
Ah, she'll give.
Pension matter.
So what a fixed date, diba? Mr. Bhattakur, Mr. Sharma, just give a date convenient to yourself. She'll do that. You ask your junior to give a convenient date.
Lordship, item number 40, hearing matter, your lordship. On the last occasion, lordship had heard it at length. Only a little portion was left for the private.
I kept it partner today. Not possible.
Today, the lordship may put it at part
After that, it will be more than 1 month. I can't keep it like that. And they'll look into it. Jot ase? Interim jot ase? Extends till the next date of listing. So, okay, G date pichare 80 dili hobo.